All right, ladies and gentlemen, good morning. I hope you're all as excited to be here as we are. Hope.
Good morning, Gary. How are you?
If you'll do us a courtesy and fellow participants, courtesy of making sure your phones are silenced, your tablets are off. You're not sitting next to somebody that wants to talk to you the whole time. We'd appreciate that. Okay, Malcolm, will you read the disclaimer into the record before we get started?
I would be glad to, Mr. Chairman.
Thank you.
I'm Malcolm Young. I'm the Executive Director of the Tennessee Real Estate Commission. The meeting date, time, and location have been noticed. Included as part of this year's meeting calendar since July 1st, 2015. Additionally, the agenda for this month's meeting has been posted on the TN Real Estate Commission's website since Thursday, May the 27th. Also, this meeting has been noticed on the tn.gov website since Thursday, May the 27th. Thank you.
All right, let me remind participants that you need to sign in. You're going to have to initial on the way out, initial when you come back in, sign out on the way out. Don't forget any of those steps to get the credit you're here to get. All right, Mr. Young, if you'll call the roll, it appears to me we have all members present, but you, for the record, may want to do that.
Okay, John Grease.
Here.
Janet DeChera.
Here.
Gary Bloom.
Here.
Diane Hills.
Here.
Austin McMillan.
Here.
Marcia Franks.
Here.
Bobby Wood.
Here.
Fontaine Taylor.
Here.
Johnny Horn.
Here.
Mr. Chairman, you have a quorum.
All right, thank you, Mr. Young. At this point, I'm going to ask Reverend Johnny Horn, member of our commission, to lead us in an invocation. And once that invocation is over, if you would please stand, he will also lead us in the pledge to the flag. Reverend Horn.
Let's pray. Father, we indeed thank you for an opportunity to share in the King's business. And Lord, we pray that you give us clarity of heart, clarity of mind, that all the things that we do, Lord, will be present, be pleasing in our sight. Father, we thank you again for living in this blessed country, in a country, Lord, that we can glorify you. We thank you now. In Jesus' name, amen.
And please stand.
Please. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Commissioner. It's now time to approve the agenda. Is there a motion or are there amendments?
Motion to approve. Second.
I have a motion by Commissioner DeChara, seconded by Commissioner Franks. The agenda be approved as submitted. Are there any changes or modifications requested by Commission or by legal counsel, Office of Legal Counsel?
The commission may want to vote on the legislative proposal for grandfathering. I know we talked about that last month, but if it's going to be a board or a commission proposed piece of legislation, then we may want to have everybody vote on it just so we have that on the record.
Okay. Where would you want to put that? In your report?
Anywhere, whatever you choose.
Let's stick it at your report.
Okay.
Okay. I've also, as far as the agenda goes, received a request from the attorney representing Scott Boroff, who's on our agenda for 10 a.m. this morning, asking that the discussion related to his license be postponed until our October meeting. So if there is no objection to that, we'll take it off this agenda and stick it on October. Scott Boroff, informal appearances, 10 a.m. You may recall, and I appreciate the Commission's understanding is probably not the right word, but we first heard this case back in Kingsport last year in October. So if indeed he shows up with his attorney in Farragut in October this year, it'll be a year since this has been on our agenda. And so you guys have been nice enough to extend it time after time. I just want to note that for the record. All right, any other amendments to the agenda? All right, you've heard the amendment offered by the Office of Legal Counsel. There is no objection to that. I think without objection, we'll add that to the agenda. Let's vote on the agenda at this point. All in favor of the agenda as submitted, please vote aye. Aye. Those opposed, no. That motion passes unanimously. All right, Mr. Young, somehow we've got a special appearance noted on our agenda from the Tennessee Association of Realtors. Would you like to give us a little background on that before we get started?
At this point, I would like to introduce Chris Sexton, and to kick it off, in Buzz Still. From the Tennessee Association of Realtors, they are basically demonstrating a new technology, which would be, I'll call it satellite classroom, in which monitors would be on site in different locations and with specific controls for classroom education, which is kind of a new approach for y'all to review this morning.
And just for the record, the Tennessee Association of Realtors is not affiliated with the Tennessee Real Estate Commission at all, although we have common membership and we think we both do good. Mr. Sexton.
Thank you, Mr. Chairman. I am Chris Sexton, for the record, the Director of Government Affairs for the Tennessee Association of
Chris, is there a microphone there that we can hear you a little better with?
Buzz has one.
Actually, this one's for purposes of our...
I'd like to make sure we get this on the record.
Yeah, sure. Let's just...
Have a seat there.
When you start talking, it comes on. It's voice activated.
I
There you go.
apologize. Okay, all right.
Sit.
Thank you, Mr. Chair. Did I play that?
He
right,
unplugged Buzz.
Sorry, Christopher Sexton with the Tennessee Association of Realtors. I'm the Director of Government Affairs. I want to thank you for granting us this pleasure. Thank you, Mr. Executive Director, for working this out. Mr. Chair, thank you for the time. We are working on various different education techniques, and I want to introduce several people here with us, some via web and some right here. Buzz Steele, one of my counterparts, he is the Director of Membership Services and has done an amazing job with everything that we do. And yes, we don't represent every single licensee, but we want to make sure that we can provide the best education that we always do. And you guys have always been very kind to work with me and work with one of my counterparts, Russ Farah, who you all know. But Buzz has done an amazing job. And then Steve McDonald, who is on your screen, he is the Director of... Wait. We're flying by the seat of our pants.
You only get so much time to do that.
Thank you, Mr. Chair.
You said you appreciated each and every one of us, so I just wanted to follow up with that.
And I appreciate you more than anybody.
That's what I say.
Director of our our professional development, Steve McDonald, and he has an instructor with us that has been approved by TREC and that has done a lot of courses that have been approved by TREC. Christy Harrison, who is from the Nashville area and works at Village Real Estate and has done an awesome job. And we just kind of want to give you a taste of what we're trying to do. And with that, I will turn it over to Buzz.
All right, thank you, Chris. Thank you, commissioners. So today what we're going to do is we're going to show you basically a live class that's going to be streamed over the web. And the idea for this is to basically be able to touch many different licensees across the state in locations where they can't come to certain geographical locations like in Nashville. We put on a lot of our education at our headquarters, which are 4 or 5 miles down the road from here. But the problem is that there's, we have 23,056 of the licensees across the state, which represents about 80% of all licensees. And we have about 23 local associations. And so what we would like to do is be able to perform live classes to those different locations, virtually the same way you would have a regular live class. In this case, you would have a monitor or proctor in the room that would basically sign an affidavit and authenticate the people that are coming in, much like they do today with turning in rosters and making sure people sign in to those classes. And so what I would like to do now is just give you a brief demonstration. Christy, can you hear me?
Yes, I can.
Okay, great. So Christy is going to go ahead and just start with a mock classroom, and this is going to be live participation so that anybody who wants to ask a question, like as if you were in a classroom, you can use this mic and I'll help pass that around. Okay, Christy, are you ready?
I am. So I want to welcome you guys to our live classroom streaming. And again, as Buzz said, if you have a question, feel free to raise your hand and I'll be taking questions at that time. When you do raise your hand and get the mic, please introduce yourself so that others can know who you are and what your question is. Today, our class that we're going to review is 5 reasons your leads aren't calling you back and how to fix it. Now, let me just say that I know there's a debate on the word leads. So for sake of argument today, when I say leads, I mean customers. I mean people who have not exactly have an agency agreement with you yet, but are calling or have inquired of your service for maybe a home that they want to sell or a home that they want to purchase. So one of the things the reason we do this course is so that we can make sure that all customers have a great experience with us as realtors. So the first thing I want you to know on this slide that I'm going to show you is that the future of successful lead generation is in providing relevant, high-quality information, understanding your audience's buying process, and following up with customers. Okay, so we know the key is in the follow-up. But how are we going to do follow-up if we don't have a determined way that we do business? So let me describe something for you. When we go on, we're going to, yes?
We have a question. Can we?
Wait, let me,
Are you
yes.
Okay, hold on.
Yes, ma'am.
How do you determine when they become a client?
So you determine when they become a client once you have a signed agency agreement. So, and that's one of the important things about this class is to determine the difference between someone who's a customer and someone who's a client. I hear all the time agents saying, well, my client this and my client that. And I always point out, if you don't have an agency agreement that's signed and been established by both parties, you don't have a client yet. And so along that thought, one of the great ways to go about developing whether or not you have a client or to get to the point where you do have a client is to do what I call developing a lead sequence. So let's talk about this on this slide. So the first thing you want to determine is this customer can come in from any avenue. So for example, they could be a call-in. Perhaps you have a sign in front of one of your listings and a customer calls that number to inquire more information about that sign. Also today, we're seeing a lot more interaction through the web. So the person might inquire of you through a website or their social portal online. So what I think, in order to make sure that you treat every client, every customer fairly, is to make sure that you figure out how to deal with them. The best way I can describe this to realtors is, say for example, you're walking into your favorite chain restaurant. It doesn't matter if I go to a Chick-fil-A that's here or if I go to one that's in Florida, which I just came from this weekend. I know what to expect. I know what's on the menu. I know how I'm going to be treated. And it's the same thing. Yes. Is there a question? Great.
Hey, Christy, Marcia Franks.
Marsha.
I did that just to see if you could see me raising my hand.
So I can see if the screen is going back and forth, and also I have someone here live with me that's helping me raise his hand as well, so I know that someone in there is raising their hand.
Okay, okay.
So I'm sorry for the delay on that. Okay.
Hold on just one second.
Absolutely.
I think that's going to be sufficient. Chairman Grease?
Members of the commission, do you get the idea? Do you need more of a presentation, or are you comfortable with what you see? Mr. Bloom?
Yes.
I can.
I just want to know, when you teach a class like that, do you have to have somebody who goes back to the picture of you and then back to your overheads? Do you have to have an assistant helping you?
Ideally, what happens with our Zoom technology that we're using, that's the platform. When the mic picks up, it should actually pick up the screen. Since this is our first time doing this, it's really not doing that yet. We're going to have to hook up our camera, which does not have a mic on it as well, and that will focus in on the person that's asking the question, or actually pick up their camera.
So this would only be done at TAR offices where you have this technology and you would have the people that are able to take care of.
Correct.
of
We
it.
would have our different locations would have a proctor. There would be certain requirements made of them as far as technology, what they would have, classes that we would have to provide them so that they could put this on.
Plus, Exit has this kind of interactive training. If you'll get in touch with me next week, I'll let you know what we're using for equipment on that.
Okay. The equipment is fairly cheap.
Yeah, ours was too, less than two. Ours was less than 200, I think, off Amazon.
So, and there'll be like the check and balance system in that this amount of people shows up on a Monday morning for a class, and then
Ideally, the
they
way
wait for, because, you know, things
The
go
proctor will
wrong.
do that.
Yeah.
Yes. So what we would want to do is basically, association and TREC would probably either do some grants or subsidies.
And then what are you looking at costs for the members?
Whatever the local association's gonna charge some. I will say this, since this is being put on by TREC, there's probably gonna be a nominal cost. I can't speak to what that's going to be yet. It's something that they'll have to determine. Very similar to our GRI, which they do have to pay a certain amount.
So, Mr. Chairman, what exactly are we being asked? Are we being asked to approve this today, or?
I think the intent is just to show it off at this point, to let us know that it potentially will come back down the pike in some form or
But
fashion.
we would love to see this implemented, you know, sometime in the future, as soon as possible. We think that we can provide a lot more education.
I think it's a fabulous idea, and it's a problem that we've been having for people who are having to drive long distances and to have hotel rooms. That expense is great in the Nashville area, and I think it's an excellent idea, and anything that we can do to help people get educated, I know I would be all for that.
Do you think this is competition for online classes?
I don't. I think this is basically a live class. It's as if you were in college and. So I don't see that. I mean, the way that we're looking at this is as if it's. I know that Texas, I believe, does it. Louisiana, I think Colorado. I'll be able to tell you all those stats.
Ross, do you have any thoughts on this at this point? Speak to the microphone if you do, please.
Thanks, Buzz, and appreciate the presentation today. I think when last we talked, we were talking about the proctors and maybe some type of presentation, at least some document that maybe Steve and you were going to put together for us.
Yes, we did talk about an affidavit from the proctor's location that they would sign.
Commissioner Horn. I'm sorry, Ross, I'll be back to you.
Okay.
Johnny, you have a question?
Okay, I would like to know how reliable is the system? What troubles could be anticipated, such as downtime? And if there is downtime, what do you do with the people who is taking valuable time out of their lives to tune in? So what I'm saying, I'm hearing all the great parts about it, but if there is some drawbacks, I'd like to know about them too.
Well, the drawbacks are that the internet's not always up. Depends on your internet service provider. Of the internet, the backbone, those are things you can't foresee. Out there, websites and things like that that are delivering 24.
And Commissioner Horn, I'd like to tell you that in Franklin, where I live, we have several churches that are using this technology. When they just can't get everybody in the sanctuary, they have an overflow in the fellowship hall, and they do this same technology. So it's not that it's something that's brand new or it's not being widely used, I would say. Isn't that right, Buzz?
Yeah, it's widely used. I mean, this is not brand new technology. It's been out there for several years now. We just want to be that they're not going to get CE and that their money would be refunded.
Commissioner Bloom.
Buzz?
Yeah, we know the guy on the left, but I'd like for us all to thank Christy for being with us. She did a great job. Let's give her a hand.
Good job, Christy.
Thank you. Thank you.
Mr. Young.
Actually, Buzz did mention that Louisiana was one of the states that had this technology. I was actually the CEO of Louisiana Realtors when we introduced this to the Real Estate Commission in Louisiana. And we started this 6 years ago, and I will tell you, if the satellite locations, if they have the appropriate bandwidth, the specified things that the Tennessee Association of Realtors requires for you to hold the class, you're not going to have an issue. And we basically did this in a flawless way.
Commissioner Wood.
I was going to say, Buzz and Chris, this actually turned out a lot better than I thought it was going to be. I mean, sometimes technology and, the people's mouth are moving and their voice comes a little later. It was really good. And where I see a use for it is, like especially from a commission standpoint, we seem to have problems with property management and getting the word out about property management. But in any given association, you're not going to pull together maybe 10 people to have enough to pay for an instructor. But in something like this is ideal, where you could disperse it throughout the state and literally have one class that can hit the whole state, and for a very specific class. And I think that's an ideal source for something like this.
CCIM courses,
Yeah.
stuff like that, big great.
Yeah.
So back to Ms. Frank's question, I sense we could probably entertain a motion that endorses the concept and let TAR know that we like the idea and to continue to refine it.
I'd like to make a motion.
Please, Ms. Franks.
I would like to make a motion that we encourage TAR to continue developing this, and that we, as the Real Estate Commission, appreciate you, and we're thankful for the opportunity to teach in this a way in the state of Tennessee. I'll second.
Okay, so there's a motion made by Ms. Franks, seconded by Mr. Charo, and I believe the motion said that it encourages TAR to continue to refine this, and we'll be receptive to this type of
That's correct.
teaching experience. All right, you've heard the motions paraphrased in some form or fashion. Any other comments on the motion before we vote? All right, then let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Now, we're done with that topic, okay? Don't go anywhere. Mr. Sexton, we have another item on the agenda later in the day that involves a request by TAR. You'll find it at 1 o'clock on the agenda. Mr. Young, can we handle that at this point?
I was about to make that recommendation.
Well, good. So that was a yes. We can handle it, right? Tell us what's up on this one.
Well, Chris, if you'll come to the podium.
But let me interrupt for a second. Mr. Gregory, are you okay for a few minutes? This won't take long. Okay.
I guess back in April, the Tennessee Association of Realtors approached staff to basically restore data feeds between the TREC and the licensee information and what they were accustomed to receiving under the old RBS system. When we switched over to Core, because of the new technology platform, this did prevent the boards of getting feeds that are a requirement of the National Association of Realtors for local associations to continue in existence. We felt like that it was best for this request to come to the commission and for their approval, and I wanted Chris to kind of go over a little bit more detail as far as what they were looking at as far as feeds, and also assuring the commission and the regulators that the information that is exchanged in the feeds is protected and the licensees are protected with the downloads. So, Chris?
Mr. Director, thank you. Mr. Chair.
You're going to have to come to a microphone, Chris.
Forget these things. Chris Sexton with the Tennessee Association of Realtors. That one's always on, so I'm sorry. Thank you, Mr. Director. Thank you, Mr. Chair, for entertaining this. I'm going to turn it over to Buzz again, but I want to thank you for your past actions and working with us on everything. But all we're looking at is just a basic data feed. And it's all public information is what we're going for. We just want it in a simple process that we can download and give up to, and it's not just for our members, it is for the public. So if you want to look up any licensee, you can look up their information and see what type of education they've taken. We tried to make it easy, and we got tarnet.com/IRMA. It's our new app that we've developed, and all it is just an education resource.
Right.
Mr. Steele, see if you can make it more concise than what Chris
Okay.
just said.
So Malcolm basically said that we have core standards that are required by the National Association of Realtors. What that means to us is that we have to basically be able to get all the licensees, names, information, things like that to the local associations or to meet core requirements. That's no longer available to us. We still have verify.tn.gov where you can find education. On top of just getting the feed, what we would like to do is integrate it with our education resource mobile app called IRMA. And that way, members would be able to check their, not members, but licensees for that matter. And this is a free app. There's no charges on it or anything. It basically has all the education across the state from all the proprietary schools that are already approved by the Real Estate Commission. What we'd like to make available, not only with that feed for the requirement that NAR has imposed upon us, but we'd also like to make the education available to all licensees who would like to download the app so that they have a one-stop shop to look up their education, and then also to find education that they may need that might be required. It would certainly be a way to cut down on hours on support and telephone here and at TAR, because it is one of the top questions that we get quite often when we have people call up and say, how many hours do I have?
Thank you. Mr. Young, so an appropriate motion, if this commission was inclined to grant the request of TAR, would be to what? Turn Core loose to?
Basically, I would make the motion to provide TAR with appropriate data feeds to support their online services, and as well as assist the local boards with non-member licensee information that is necessary for them to operate.
So move. You said.
Is another way of saying that to restore what they used to have?
I think that would be appropriate.
I
Okay.
think it also needs to add and to integrate, be allowed to integrate with IRMA.
Yes. Now, if you say restore, I just want to make this clear. Restore, what we used to have, basically everybody did, was a download, a PDF. Then you got to go in there and you've got to strip the material, and then you've got to put it into a database.
Okay, yeah.
What we're asking for is a data feed
Data
that will
feed.
go to a secure server. We will jump through the hoops, whatever the requirements are that you have of us as far as security or anything like that. We just want it to be in a format that is easily, that we can manipulate. And we have already spoken with Janet LaRosa from the state, the IT and IT department, and she says it's simple enough to do.
Mallory, does legal have any problem with this?
Well, I just had a question. So are we just, the data you're talking about, are we just talking about education only?
Licensee information, office information.
What kind of licensee information?
Just whatever's public record.
Whatever is public record, that was public record before, which would basically be their office information, when their licensing renewal date is. Because what we would like to do is make this so easy that if somebody needed 16 hours, that if they downloaded our app, that we could tell them, you've got 8 hours, you need 8 hours more, you're missing 2 hours.
They can do that right now by going on the government
Yes, they can,
website.
but they have to actually, maneuver through the website, find all that. Most people don't know what the verify.tn.gov is there. That's mostly for the public, but it has become a tool that licensees use on a daily basis when they're required to have certain hours.
And I will say that we get a lot of calls, and I'm sure TREC gets a lot of calls, where they don't know the difference between TAR or TREC. So we're just trying to make this process simplified.
And I've noticed that I was actually on it yesterday trying to verify did somebody have a license or not, and did they have a firm address or not. And it doesn't say what company that you're with. And we really need that, because if, as a principal broker myself, if I need to speak to someone else's principal broker, I need to know who that principal broker is. If it just said Keller Williams, there's lots of those. So that information really needs to be on there.
I think that's in core. Aren't we supposed to get to that point, Malcolm, where we
Yes.
can get full information about each licensee?
Absolutely.
Thank
And
you.
basically, this would be a data feed from CORE that would be providing their platform with that information.
It would just be a different file format.
Just as an aside, may I ask a question?
Sure.
In looking up things, let's say I looked up Keller Williams, a certain branch. Would I be able to tell who the managing broker is in reverse? Like, if I'm trying to reach that managing broker? Not now. Is that a possibility? Because I think that's as important as,
Definitely take that to IT.
right, okay.
Need to take
Would
that
save
back
a
to-
step
yeah.
for sure.
Absolutely.
Oh, so Ms. Kirby, do you have an objection to this request for the data feed, or I know you had a little hesitation in your question?
Well, this is the first I've heard of it, so I don't right now, but I may need to think about it.
And Mr. Chairman, I'm sorry, I am a little technologically inhibited, I guess. I'm just trying to understand what they're asking for. So the Tennessee Association of Realtors is asking for access to publicly available data that the state has through some sort of transfer of
already
that
public.
data that we're calling the
Yes,
feed.
and it used to be available, and it's no longer available.
Okay, but it's public information.
Right, and if it does become available again, what we're really asking is that the file format is easy enough, not just for us, but other people to be able to use and manipulate the data. Because right now, it's in PDF, which is I don't want to get too far into the technical business, but it is a static file. You can't do anything with those.
I understand what you're saying there. Malcolm, do you know, will there be any expense to the state to provide this data in this way?
With our meeting with Janet LaRosa, who's the IT person, she felt like that there would be the expense to the state as far as providing the information.
Commissioner McMullen, you know, we're not asking for the moon here. I mean, we don't want to have to file a FOIA request every single time, and
Right.
I don't think TREC wants to deal with that.
Right, that's what I was trying to, I mean, I think
Yeah.
you probably could get this information going
Exactly.
that way,
Yeah,
and I'm just,
but, I mean, it'd be an everyday type of thing, and
Right.
it would be a disservice to the public and real estate licensees in our
I was just trying to make sure I understood what you were asking for, and then just if there was any kind of increased expense to the state, I guess, I mean, if that came around, would TAR be willing to pay whatever, if reasonable, whatever that expense is, I guess, or could make that decision at that time?
Shouldn't be an expense.
Yeah.
If it's a FOIA thing, I mean.
The
it
only
shouldn't be an
expense is going to be on us, and that's
Okay.
making sure that we have our servers and our software.
Ms. Taylor.
I would say that this would be a great benefit to all the public in every way, and I commend TAR for taking this step and helping the public in making life easier for not only the agents, but the public themselves.
Ms. Kirby.
I think the concept is good and the idea behind it. I just have a little bit of hesitancy because there is information that's in licensees' files on our system that's not public record and can't be. So I just want to make sure if we were to do anything like this, that it would be set up in such a way to ensure that it was only the things that are public record.
It's going to be your feed. Whatever data that you decide to give us, it would be up to you to do that. We're asking for everything that is available publicly. If there's something down the road which we think that could benefit everybody, whether that be, renewal dates on E&O, renewal dates on licensure, privilege tax, anything else like that, that would be up to you guys to decide what you would allow. But right now, we're just asking for the public.
Because I think a lot of people, Austin, they'll like, for instance, in my case, they might call WCAR, Williamson County Association of Realtors, and they'll say, well, we don't deal with that. Then they might call TAR because they don't know who else to call. And TAR doesn't have that information either. And it's mostly about, do I need classes and my education hours? That's what it's mostly about. And then when all else fails, if they know me and I'm a real estate commissioner, they'll call me. And then I have to say, well, you need to call Malcolm or you need to go online. So that's a lot of steps for anybody just to find out if they don't know where they can get their information.
I do think that the two key words here is information that's public information, and also the reassurance that our data is downloaded to a secured site at TAR.
Right.
I think those are two key words that definitely need to be part of the motion.
But the motion includes, if that data hits TAR, they're going to disseminate it to all the local associations. I mean, that's a standard of NAR, isn't it, to do that?
Correct, and we do that already the old way. We get a PDF file and say, here you go.
So if it's a data feed to a secure server at TAR, and then you guys send it to the Knoxville Area Association of Realtors, is that a secure site you're sending it to as well?
Well, basically, we would send them the data that they would need, whether it be an Excel spreadsheet or it be in a PDF. So it is the same process, except that we would make it easier. In other words, in Knoxville, we could just say, here's the licensees that you need, not all of them across the state.
It would be a link to our site, which would be secure.
Yes, we could do that as well.
Kirby, I need for you to be comfortable.
I think I'm comfortable
Okay.
right now. I mean, without knowing specifically all the details, but yeah, I'm comfortable right now.
As long as it's public information or information available to the public.
Yes, I mean, I'm comfortable with it. I think it would probably be something we would need to run by the assistant commissioner in order to implement it. But I mean, the commission can certainly go ahead and
Subject to.
Yeah, do you agree, Malcolm, that it would be something that we'd need to run by Brian? And
Well, actually, Brian kicked it here
he did. Okay.
because it was originally in Brian's office.
All right, so this motion, we have a motion on the floor that basically approves the request to TAR. Should it be subject to the Department of Commerce and Insurance approval?
They basically sent it here because the original request went to Brian McCormick, and then he requested that it come here for y'all's approval.
All right, so The chair believes the motion on the floor is to approve TAR's request for the data feed. And they can do what they want to with it, but what they need is the data feed. Is there a discussion on the motion? Are you ready to vote? All right, those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously.
Thank you,
Thanks,
Commissioners.
Ben. All right. I skipped one item on the agenda. We have to approve the minutes of last month's meeting. Is there a motion?
Motion to approve.
I have
Second.
a motion by Commissioner Chara, seconded by Commissioner Franks, that last month's minutes as submitted to us be approved. Is there discussion, corrections, or amendments? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously.
Mullen abstains.
Commissioner McMullen abstains. All right. To the audience, a couple of things. We were scheduled for a two-day meeting here. The formal hearing we had scheduled for tomorrow has been moved, so we won't meet tomorrow. How long we meet today is anybody's guess at this point, okay? But for lunch purposes, probably you ought to be thinking about leaving here about 11:45 and coming back about 5 after 1 kind of period of time. That's going to be a little bit subject to how this meeting goes this morning. So if you have appointments or phone calls you need to make, we'll have a break between now and lunch break, but please stay off your phone at this point. All right, this is a little bit unusual for us. We have Dennis Gregory, who's with Office of Legal Counsel. Mr. Gregory, are you ready to go? All right. The agenda item is related to licensee Blythe Sanders, and we have on our agenda, which we've approved, a summary suspension hearing. Mr. Gregory, would you like to give us what information we need to know?
Do members of the commission have some of the copies of there's not a whole lot for you all to take a look at, but I believe if you want to go ahead, I can kind of begin to talk and explain the basis. Commission had originally received a letter from the respondent, Mr. Sanders, Blythe Bond Sanders III. Actually, I believe it was addressed to specifically to Commissioner McMullen, informing the commission that he had pled guilty in the Eastern District of Tennessee to a well, the letter doesn't go into a lot of detail, but he attached a plea agreement. You'll see that it's roughly looks to be about 9 pages long. Attached a plea agreement showing where he had pled guilty to one count of conspiracy to commit bank fraud. Based on the data, the factual basis in the plea agreement, the agency thought that it was warranted to take up the matter in the form of summary suspension. Of course, this is not, to be clear, there's two types of summary suspensions. One where it's just someone is summarily suspended and then you have a hearing later to decide whether or not it goes forward. This is rather the second version where that he was put on notice to show up today. You all hear the facts, decide whether or not that the public, that there is a public danger based on the information found in the plea agreement, and can suspend or not suspend at that point. He was notified. I think we've got a copy of the original green card, so there was a letter from me to him explaining what the basis of the hearing was going to be, or conference was going to, what issues we were going to talk about, and he has opted not to show up based, I believe, primarily on his advice of counsel, who is also in Knoxville. There's a letter that you all probably should take a look at as well that'll give you an idea why that he's not here. This is the one that's got the heading on it of the Leibowitz law firm, and it's the undersigned is a Jennifer Himmelgarn. Effectively, he's pled guilty, but he has not been sentenced. And the concern is that he would say something today that potentially might impact the sentencing. That's why he's not here.
Well, before we take a few minutes to look at that letter, would you tell us what our decision is today? Are we going to have a hearing? Could we have had a hearing, or is this strictly a one little topic issue we're handling that we make yes or no vote on?
Essentially, the hearing, yes, we could have the hearing today. But he's on notice. There's no reason. It's merely just to decide whether or not that, based on his guilty plea, not his sentence, but the position the agency takes is that the sentence, whatever it may be, it's not going to be until next month, is really irrelevant. What we believe is the damaging portion, the portion that can be considered to be a threat to the public interest, is what's already contained in the plea agreement. So we could have this hearing today. Another option, of course, is to push it to a later date. You'll notice in Ms. Himmelgren's letter, she talks about a couple other alternate dates that would be after his sentencing. But our position is that it's right to be heard today.
Can I say something real quick, Dennis? Sure. So the whole reason that Mr. Sanders notified us about this conviction was because in our statute, in our Broker Act, it says if you've been convicted of a certain type of crime, your license is automatically revoked unless you request a hearing within 60 days of your conviction. Mr. Sanders requested a hearing within 60 days of his conviction. Now, as you know, because of the judge's dates, availability, and stuff, we won't be able to have that hearing for a while. So this hearing today is just to decide whether you want to suspend his license until he can actually have a full hearing with a judge to determine whether his license should be revoked or not.
Does the state bring a recommendation on that?
The recommendation is for today, at least, to approve a summary suspension.
So that's what's in front of us?
Yes.
Thank you. All right, Commissioners, you may want to look through this material, and then we'll see what questions you might have.
What did he plead guilty of?
Mr. Gregory.
One count of conspiracy to commit bank fraud as part of a real estate transaction.
Ms. Kirby, can you tell us again what our responsibility is today?
Yes, so today you're just deciding whether you want to suspend Mr. Sanders' license until a full hearing before a judge can take place to determine whether it should be fully revoked or not. So if you decide not to suspend him today, then he has an active license up until that hearing takes place, which, I don't know when that will be. It has to be set with the judge and will probably be like next year sometime. And then, of course, if you do suspend him today, then he won't have a license up. He won't be able to use his license up until the hearing takes place.
So the state is looking at this as an emergency situation. Is that why we're doing this now?
Yes.
I being a relatively new member, is this something we have done? Is there precedent to this?
Well, since I've been here, no one who has actually been convicted of any of the types of crimes enumerated in the statute has notified us within 60 days and requested a hearing. So since I've been here, this is the first time we've had this situation. Usually when this kind of thing happens, they don't tell us, and we either find out via the news or somebody sends me an article that shows it. But this case, he notified us, so.
Is there some reason he sent it to Commissioner McMullen?
I have to ask Commissioner McMullen that.
Do you
I don't
know this
know.
person?
No, I think there was reference made to a conversation that I had with a Tom Rice, and I may have spoken with former Commissioner Stevenson. I seem to recall getting a call from Tom Rice. I can't remember whether I spoke with Commissioner Stevenson about it or not. And honestly, I can't remember much, if anything, of what we actually talked about, but I do seem to remember getting a call about a person who had some sort of conviction. That's really all I can remember. But I don't know why it was addressed to me at the Real Estate Commission.
Commissioner Horn.
I have a little bit of a problem with the cognitive department. It seems as though, just applying here what was written, that if you can do enough challenges to anything, we can just keep postponing. I keep operating, I keep selling. And it seems to me that if the person has admitted that he was at least partially involved in fraud, then his license should be, he shouldn't be allowed to do any other work until this is taken off of his, decided one way or the other.
Commissioner, other comments?
Could you just tell us in a small way, what exactly did he do?
He and another individual, and if you, to be honest, if you were to look through pages 2 and 3 of the plea agreement, really the only thing that, I don't say only thing, but the genesis of Mr. Sanders' problem is captured in subparagraph A, where there was a short sale of some property in the Knoxville area that appeared to be at an arm's length transaction when really was not. That paragraph right there is really what captures what he pled guilty to.
Ms. Kirby, it's noted on here that Mr. Stevenson is here to give us information. Is it appropriate for us to hear from him?
I'll let Dennis answer.
Well, appropriate, here's the concern I guess the agency would have is, first, a former member of the commission. We don't know what impact, obviously, that he would, or sway he would have on the commission. 2, while Mr. Sanders is entitled to witnesses, if he were here or his attorney was here, Mr. Stevenson could be called as a witness. I suppose he's sort of being called as a bit of a witness informally. He's here. I'm not sure exactly what he's going to tell the commission. I believe probably it's going to be essentially push this to the right, allow Mr. Sanders to have his sentencing hearing, then this issue is going to be more ripe, and then the commission summary suspension is appropriate. So to say that he's not, or that Mr. Sanders would not be entitled to any witnesses would be wrong. But I can't say that hearing from Mr. Stevenson is wrong either. It's just that I just want you to kind of take that with a grain of salt if and when he does make any statement.
Why did his attorney not come today to represent him?
I believe that she had a scheduling conflict, and then the reason that Mr. Sanders is not here is on her advice not to show up because he might say something that could potentially impact the sentencing hearing. But I think practically she just had a conflict.
Ms. Hills.
So can we, so the sentencing will be in July. Is there a way, and I read something, I can't lay my hands on it, that it suggests then we could have the hearing in August, September, or October when we're going to be in Farragut. Is there a way that we can know that it would be in August? I mean,
you could make a motion, and if it had enough votes, you could defer this till our August meeting.
But that would let him keep his license.
Correct.
And again, we don't think that the sentence is the issue here. The issue is what he's already pled guilty to. In federal court, generally, the defendant will plead guilty, and then there's a pre-sentence report that has to be done by the U.S. Probation Service, and then the defendant's called back to court. The judge issues a sentence, and then whatever happens, happens. Either the person goes, incarcerated, or isn't incarcerated, or begins some kind of probation. Any number of things that could happen.
With short sales, and that looks like what this is, I mean, I would just like to, they're most difficult thing we deal with, and sometimes you can be caught up in something that someone else has done, and you're caught up in it, but just because you're already you're involved in it. So
You have the floor, Ms. Hills, if you'd like to make a motion.
I'd like to make a motion that that we delay our hearing until our August meeting.
All right, there's a motion on the floor, and basically that's just to defer this item until August. Is that,
And leave the license.
if you defer it until August, that he
Okay.
still stays
All right.
active. That's
I'll second that.
May I address the commission?
You may. Let me make sure I understand the motion. We've got a motion by Ms. Hill, seconded by Mr. Char, that this item be removed from today's agenda and placed on the August TREC agenda. That's the motion properly made and second. Ms. Kirby.
I just feel like I need to bring to the commission's attention that very recently the commission voted to downgrade somebody's license based basically on one email, and on the appeal, when the attorney requested a stay for that decision, this commission voted to deny that stay because of the harm to the public. And now we have a convicted felon here that was directly related to a real estate transaction. So obviously the commission can make whatever decision you feel is necessary, but I just wanted to bring that to your attention because, you know, you do want to be consistent with your decisions.
Here's my problem, Ms. Kirby. We've been told to read page 2 and page 3. I don't see Blythe Sanders mentioned in this transaction at all. So I'm having a real issue trying to figure out exactly what he supposedly did.
But it says
Present.
defendant and co-defendants. The co-defendants the defendant is Mr. Sanders, and the co-defendants are the other folks, these Mubaraks, Michael Mubarak and Diane Mubarak.
This is his specific plea agreement, so he's the one referred to as a defendant here in this document.
And so what was his part in it is what we're still missing.
He fabricated that the woman who was supposed to be married to this gentleman and named Mubarak was really the purchaser by her maiden name.
Oh, they used her maiden name.
And then in paragraph E, as I read it, it says that he falsely notarized forged signatures on real estate documents.
I speak against the motion. I think
You're
that
welcome to offer a substitute motion. You're gonna have- it will take-
order this,
All right.
well, substitute
will.
motion. Is
But-
this the time for that?
Yes,
Let-
yes. But let's go ahead.
Let us
Well,
do it.
and I guess I'll offer a substitute motion that we suspend the license pending final hearing with the ALJ to be scheduled as soon as possible. And the reason,
I have a
Okay.
second to that.
Second.
Okay, motions, we have a substitute motion properly made and seconded, made by Commissioner McMullen, seconded by Ms. Franks. Rationale.
I'll speak about why I made that motion, but I also think that unless legal counsel tells us that we can't, I would be willing to hear what Mr. Stevenson has to say to us if he wants to speak, because I understand this is an informal hearing, and unless I'm wrong, Mr. Stevenson, I assume, is his principal broker. And in those kind of situations, we usually do hear from the principal broker. Now, I know that Mr. Sanders is not here, and I understand why he's not here, although, I'm disappointed he's not here. But I think it would be appropriate if Mr. Stevenson wants to speak, and he's the principal broker, to hear him. But the reason I made the motion is, I guess, one, because of what I do see that Mr. Sanders admitted to doing in this document, including notarizing the forged documents, and his involvement in this transaction in which people's names were misrepresented, that caused this fraud in connection with this real estate transaction. Ultimately, maybe he'll come in here with some fabulous explanation about why, and we'll all be, understanding, and we'll say, well, we don't think you ought to be punished. That's fine. But until then, all we have is this. And I think we do have an obligation to protect the public. Like Ms. Kirby said, we have had other situations where we have suspended or downgraded licenses, maybe on not as strong evidence as this, arguably. And the other thing I was looking at is just the section of our code which talks about what's supposed to happen in this situation. And Ms. Kirby, you can tell me if I'm misunderstanding it, but the way I read it, it says that when somebody has a conviction that's covered, which this is, that they have to notify the commission within 60 days and that their license will be automatically revoked unless they request a hearing within 60 days. So kind of the default is revocation. Now, Mr. Sanders has requested a hearing, but then he didn't show up at his hearing, which again, I understand he's got a Fifth Amendment right to not incriminate himself, but he requested this hearing and then he's not here. Now, to just suspend it rather than go with the automatic revocation, I think is in some ways, being somewhat generous to him. And we are only suspending it until we actually have that hearing. Now, I know he would probably prefer to just completely keep the license, but we have to balance that interest, I think, against the threat to the public. And when we have a person who the documents say notarized forged signatures, and we don't know what all he knew about this transaction, but he admitted to that, I think we have to see that that's a threat to the public, and we need to act to protect the public. So, long explanation, but that's my thinking on it.
Ms. Kirby, this, as far as a hearing, we didn't have a formal hearing scheduled, is that correct?
No, not yet. So the hearing that Austin was referring to in the statute will be the formal hearing with the judge and the commission and all of that. This hearing today was the summary suspension hearing, which is not a part of the broker statute. It's part of the administrative procedures. So if the commission, it's brought to the commission that there's imminent harm to the public based on something the licensee has done, then we can have a hearing like we're having today to suspend the license until a formal hearing can take place.
Okay, so just to get everybody current, we had a motion on the floor offered by Ms. Hill, seconded by Mr. Char, that this topic be moved to our August agenda. A substitute motion was made by Commissioner McMullen, seconded by Ms. Franks, that said, basically, let's accept the state's recommendation and immediately suspend Mr. Sanders' license. That's what's in front of us. Now, back to you, Mr. McMullen. Was offering the opportunity to Mr. Stevenson to speak part of your motion, or was that a separate topic?
That was just observation on my part. It wasn't part of the motion. I mean, I would be open to that if that's something the commission wanted to do and something Mr. Stevenson wanted to speak to. Since it is an informal hearing, we often hear principal brokers in that kind of situation. I assume Mr. Stevenson is Mr. Sanders' principal broker, and so I would be willing to hear Mr. Stevenson, but that's really up to the commission.
Well, so if it's up to the commission, if a member of the commission would like to make a motion to allow Mr. Stevenson to speak, please make that motion.
I'll make the motion we allow Mr. Stevenson to speak.
Second.
I've got a motion by Mr. Chara, seconded by Ms. Franks, that upon majority vote, Mr. Stevenson, if he's so inclined, can address the commission. Is there a discussion on that motion? All right, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed?
No.
One no. Mr. Taylor, the chair, recuses himself on the vote. All right, Mr. Stevenson, are you interested in addressing the commission?
Yes, I am, Mr. Chair.
Do we need to swear this guy in or anything, Ms. Kirby?
No, we don't need to.
Okay. All right, give us your name and address for the record, sir.
I'm William Bear Stevenson, owner of Stevenson Realty and Auction in Clinton, Tennessee. And I feel a little nervous down here. The 10 years I was sitting up there, I've had more empathy now for people who came before us. But anyway, in 2006, I get a call from Blythe Bond Sanders, just out of the clear blue. He said, Bear, he said, I don't know you and you don't know me, but he said, I'm going to get my real estate license, and everybody I talk to says I need to put it with you. I said, well, I'm glad you've been talking to somebody that says something nice about me. So I just sort of forgot about it, and about a week and a half later, he called me back. He said, Bear, I want to meet with you. I said, okay, let's have breakfast in the morning. So we did. And Blythe let me know he was from Nashville, and his grandmother was a realtor here in Nashville. His father is a realtor. And while working at a title company here in Nashville, he met a young lady from my home county, and she was divorced with 2 children, and they got married, and she wanted to move back home, so they moved back to Norris, Tennessee, there in Anderson County. He went 1 year to Lipscomb, transferred to UT, and got his degree from the University of Tennessee. I told him, I said, Blythe, I said, I don't have a formal training program for new agents. He said, Bear, he said, I've been working in the title business. He said, as a matter of fact, I own half of a title company now in Knoxville, residential title and escrow. And he said, I am very knowledgeable of contracts, agency, and he said, you won't have to spend a whole lot of time training me. I said, there's 2 things I want to ask of you. The first one is, since I'm on the commission, I said, don't you do anything that's going to give me a black eye or to give Governor Bredesen, who appointed me, a black eye. I want you to make sure you cross all T's and dot all I's. He said, okay. That was 10 years ago. Fast forward up until in January of 2011 is when this situation occurred. And I've been asked by counsel to his counsel, his attorney, not to say anything or as little as possible about the facts of the case, because this is public record being recorded. He's going to be sentenced on the 26th of July. March of last year, I get a call about 8 o'clock in the morning. Somebody asked me, he said, have you seen the Knoxville News Sentinel today? I said, no. He said, you need to go get one. So I did. And there are the headlines above the fold, front page, is the indictments of a fellow by the name of Mubarak, his wife, and Blythe, and alleging all of this conspiracy thing about all going on. I called Blythe. I said, Blythe, we need to meet as soon as you can get to my office. He came down. We met for about an hour. And then I said, tell me what this is all about. And he did. What he's charged with is notarizing a signature that he was led to believe was an authentic signature in going with this short sale. The reason it's in his wife's maiden name is because the fellow Mubarak came to Blythe, who he had been closing some loans for, some transactions. He and a good friend of mine developed a subdivision in Lenore City, and Blythe had been closing lot loans, lot sales. But anyway, Mubarak said, I want to do a short sale. My son owns it. I want to put it in my ex-wife's name. Well, Blythe didn't know it, but they were still married. But a signature came. Blythe said, hey, take these to your son and get him to sign them. Well, he made a few mistakes in this whole effort. But anyway, Mubarak brought the documents back. And Blythe asked him, said, is this your son's signature? He said, yes. So Blythe notarized what he thought was his son's signature. It was not. It was a forgery that Mubarak had done. That is what he has been indicted for. That one thing happened over 5 years ago. And since then, he shut his title company down. He closed it June the 30th of last year. He's no longer a notary. He gave that up. I've been a notary continuously for 43 years. I came back from Vietnam and worked in banking. In 1973, I was assistant branch manager of a bank in my hometown, and they wanted me to become a notary, which I did, and I've been one ever since. And I have been notarizing a lot of documents through the years. But anyway, just to tell you a little bit, and I know your job is to protect the citizens of this state. 2012, Blythe Bond Sanders had 29 closings. In 2013, he had 40. 2014, he had 48. Last year, he had 64. Most of these are houses. Probably 90% of them are houses. He was either the buyer's agent or the listing agent. But up to this date, he's had 32 closings. Blythe and I talk at least every other day, usually daily. And I can assure this commission, Blythe Sanders is no threat to the citizens of this state. And I, as his principal broker, to me, he's 36 years old. He came to me, he was 26. He's 36 now. He's like a son to me. I've never had a son, but he's like the son I never had. But I can assure this commission that he is no threat to anybody in this state. But to add one more thing, after I met with Blythe, the next phone call I made was to David Flitcroft. I said, David, can I come down there and see you right now? He said, yes. So I went down to his office in Oak Ridge, 8 miles away, and I walked in there with that Knoxville News Sentinel, and I laid it down on his desk. I said, have you seen this? He said, no. I said, read it. He read that article. He looked up at me, and he said, doesn't he have his Blythe Sanders has his license with you, doesn't he? I said, yeah. He said, did you know anything about this? I said, heavens, no. I said, this happened in 2000 and December of 10 and January of 11. I said, this happened almost 5 years ago. I didn't know anything about it. He said, you have anything to do with it? I said, no, didn't know anything about it. And I asked him, I said, I want your advice, David. Would you, if you were me, would you broker release him? He said, no. He said, I think in America you're innocent until proved guilty. Well, he was offered this plea agreement. Blythe told me last fall, he said, Bear, I want this to be over. Whatever the outcome, I just want it to be over. It's already cost him a lot of money in attorney's fees. He said, I want it to be over. He said, I just want to go ahead and plead. He said, I got two choices, either plead to what they're offering me or spend another $100,000 taking it to trial. He said, I just want it over. I said, that's your call, Blythe. And what he pled to, I sat in the courtroom March the 3rd, 3 months ago with his wife, and listened to the plea that was entered and how he, with his attorney beside him, answering all the questions that the judge asked. And here we are.
Okay, Commissioners, let me say this to you, Mr. Stevenson. I know it's uncomfortable for you to go through that. You've also, I suspect, put commissioners up here in an uncomfortable position as well. And so I don't want you to think anything that happens for or against Blythe is personal. It's strictly...
I would never do that. But I just wanted to, and I told his attorney, I said, I would just like, if I had the opportunity, to tell the commission that Blythe Sanders is not a threat to anybody. I can assure the commission of that, but I mean, it's in your hands.
Thank you. Mayor, questions for Mr. Stevenson? Mr. Horn.
Yes, I have one, sir. Probably lucky for me, I was not around when that came. But however, you said something that brought my antenna up. You were saying how long you've been a notary?
I've been a notary for 43 years.
Yeah, okay, great. What I'm saying here, will you notarize my signature without not seeing me sign it?
No, sir.
Okay.
All right, other questions? So here's the motion on the floor. The motion is to accept the state's recommendation and suspend the license of Blythe Sanders pending a formal hearing. That's what's in front of us. If you're in favor of that motion, after we finish discussion, you'll vote yes. If you're opposed to it, you'll vote no. Is there a discussion? Is there a desire for a roll call vote? Let's try a voice vote and see. If you're in favor of the motion to automatically or immediately suspend the license of Blythe Sanders, please vote aye.
Aye.
If you're opposed, vote no.
No.
All right. The chair recuses himself. The motion passes on a vote of 7 aye, 1 no, and 1 recusal. Thank you, Mr. Stevenson. Appreciate you coming. Thank you, Mr. Gregory. Appreciate your presentation as well. Is there any other business on this topic that we need to handle at this point?
Mr. Chairman, no, we've got a proposed order of summary suspension. I don't know if you want to take that up now or later. It'll be under the Vice Chairman's signature, but we have one.
Want to read it into the records just so we know what she's signing and we...
Sure. Matter of Blythe Bond Sanders III, license number 291243. Complaint number REC-RBS 2016-02-606 was presented to the Tennessee Real Estate Commission of the Department of Commerce and Insurance, hereafter referred to as the Commission, on June 1st, 2016, pursuant to the provisions of Tennessee Code Annotated 4-5-320, subsection C, and Tennessee Code Annotated 4-5-320, subsection D1A, which states in pertinent part as follows: if the agency finds that public health, safety, or welfare imperatively requires emergency action and incorporates a finding to that effect in its order, summary suspension of a license may be ordered pending proceedings for revocation or other action. The agency shall issue a notice to the licensee providing an opportunity for a prompt informal hearing, review, or conference before the agency prior to the issuance of an order of summary suspension. Whereas the Commission made the following findings on June 1st, 2016, that Blythe Bond Sanders III pleaded guilty to a single count of conspiracy to commit bank fraud in violation of 18 U.S.C. 1349 in the U.S. District Court for the Eastern District of Tennessee on January 29th, 2016. That respondent is licensed by the State of Tennessee Department of Commerce Insurance, Tennessee Real Estate Commission, as a real estate agent, license number 291243. Because the nature of the alleged violations and the seriousness of the alleged violations, the Commission has determined that the health, safety, and welfare of the public imperatively require emergency action. Is therefore ordered that the real estate agent license of Blythe Bond Sanders III, number 291243, is summarily suspended as of June 1st, 2016, pending proceedings for revocation or other action.
So it'll be over your signature. Okay, thank you, Mr. Gregory. So I guess the next step is to get a formal hearing scheduled.
Correct.
And
The other option is to open a complaint and let it go through that process first. Is that right, Mark? Or
No, you need to, it can move straight to a hearing.
it can't? Okay. So we can go ahead and schedule that, I guess.
My concern that it get lost in the system and this person just go delay, and it may be January next year we have a hearing.
Well, it still could potentially be January of next year based on how many dates would be available for the ALJ and then what,
Well,
it could be that long.
Do we have an ALJ lined up for Farragut?
I don't know.
Because I know that we don't have a hearing set up for Farragut at this time. But we did vote to have 2 days of hearings in December in addition.
The 12th
Have
and
those
13th.
dates already been filled?
I believe they have been set for TREC.
Let's get Blythe in ASAP. I mean,
Yeah, I would ask.
That
if-
would be our
My whole
request.
concern for this, that
Yeah.
Okay, we'll look into October is when we go to Farragut, right? So we'll look into October, and then if not, we'll look at December.
well, I think he said he was available August or September as well. So if we've had a cancellation on those hearings, so.
all right, Mr. Stevenson, I know it wasn't easy for you. We appreciate you coming down. I know Blythe does as well.
first licensed as a broker on February the 2nd, 2007, became principal broker of the firm effective August 27, 2014. Mr. Green is responsible for supervising 5 agents. There have been 0 complaints filed against his firm. His firm is the real estate firm at 601 Concord Street, Suite 200, Knoxville, Tennessee. For Ms. Widener, the summary of the disciplinary sanctions is a felony of aggravated robbery, arrested November 1995, convicted 8 years, and Ms. Widener's statement and letters of recommendations can be found on the iPads.
All right, Ms. Widener, tell us what happened. Tell us and you don't have to tell us anything if you don't want to, but you tell us everything you'd like for us to know about you and the events. And you have to speak to that microphone so we can pick it up.
I was 18 for 2 months and 11 days when these events occurred. It was actually February 28th, 1995. I had some boys that I hung around with that I knew weren't approved people by my family. They asked me if I would drive a car for them while they robbed a convenience store. I thought about it, and I thought it was more important to me in that moment to fit in and to belong with this group of people than to think about my future and how my actions in that moment could affect my future forever. So I made the choice to drive that car. The next day, they approached me again and asked me again if I would drive the car again, and I made an excuse and said I couldn't do it. In the end, I went back because I feared that they would reject me, and I said I would, and I drove the car again. That night, a police cruiser pulled behind us as soon as we had left the store, and I immediately pulled over. When the police officer took me out of the car, he said, "Do you know?" And I was like, "Yes." And I think for the first time in my life, I took responsibility for my actions, and I knew in that moment that, my future was definitely going to be changed. That night, after questioning, when the police officers asked me, what had happened, I started with the day before, and I told the complete truth, the total truth. I was accepting whatever punishment that there was. I asked God that night when they finally put me in a jail cell to not open the doors until he knew I would never be back. And that's been over 20 years ago. I did serve 3.5 years in the Tennessee Women's Prison here in Nashville. But even during that time, I worked for the Tennessee Department of Corrections downtown with Nola Butler. And I'll be 40 this year, and I just ask you all to think long in your heart who you are at 18 and who you are at almost 40. I'm not the same person that I was at that point. I'm active in my community. I do lots of volunteer work through my church and on my own. I tutor first and second grade school children through my church. I'm not the same person. I'm willing to answer whatever question you have for me.
All right, Commissioners, questions for Ms. Widener. Mr. McMullen.
Ms. Widener, why do you want to be a real estate licensee?
My aunt is a real estate realtor, and I've been around her since she was licensed back in the 90s. I currently work in the real estate office. I answer phone and help with billing and help, make copies for agents if needed. And so I've gotten the opportunity to be around the environment, and I really like it. I've learned through taking my class and then just being there during transactions and hearing the agents. But really, I want to be a property manager. That's what I'm really coming before you. That's the position that I've applied for. And if you grant me a license, then hopefully I'll be hired for. Because I like when the tenants come in, the interaction and just really getting to know who it is and being able to make a difference. So that's why I want my real estate license.
Thank you.
Ms. Franks.
What experience do you have in property management?
None.
Okay.
So-
So what is your plan? How will you know what to do?
Well, I'm quick on my feet, and I've watched some of the current staff members, and basically, as the job's been described to me, I'll be responsible for listing the properties of our owners when they come available, showing all showings. So, and then lease prices are set by the owners, or rent rates are set by the owners. So then I would be responsible for going to KCDC and THDA to fill out Section 8 paperwork and sign leases that way. Rent collection, my goal would be to have at least a 95% rent collection each month. I'm hoping, based on your decision today, hoping that I'll manage over 100 houses between Knox County and Blount County.
So are there any classes that you're planning on taking to learn about property management?
I've gone to the places like Zulu and Zillow and some other places, and I've read information. I've looked at websites of other property management companies, but I actually was pretty excited when I heard you all mention today that maybe you do a class on property management for property managers. I would definitely be there.
So the people that you're working with now, are they licensed real estate agents?
Yes, ma'am.
Okay.
Other questions? Mr. Horn.
Yes, ma'am. Have you satisfied the state with all your forfeitures and fines and that type of thing?
Yes, sir.
So you free of them now
Yes,
at that
sir.
time? Okay. You have any contact with old friends, such as the ones who asked you to drive them around?
I haven't spoke to them since 1995.
Well, the first time I could see it. The second time, as we say, you don't learn anything from the second kick of a mule, So I wish you luck.
Thank you.
Ms. Taylor.
I would like to know what you have in mind for her education, or what do you do with a new hiree like this?
Yes. Of course, Ms. Widener's been working in the office actually for about a year and a half. Her aunt is a licensed agent with our firm. Fantastic agent, many years in the business, and we as a whole, as far as the company goes, we will train her, put her with the right people, give her the information that's going to be most helpful in the position that she wants to.
Known that wasn't the right thing to do, but I wouldn't have ever thought it was a felony. So,
I didn't either at the time, and
well, just
it
make
won't
her
happen
proud.
again.
All right, you all are free to go.
Thank you.
Thanks for coming down.
So, is it,
So, this is on YouTube, so you can go get a copy of this YouTube edition, show it to anybody that has any questions
Coach
for you.
Mommy might not go ahead and tell her.
Hey, Mr. Martin, let's get this clear. I'm sorry, Mr. Mitchell. Is there any kind of administrative process that has to happen now that we've had this vote?
Oh, he's good.
You're good. Okay. Just go finish up whatever.
He's good to move on to whatever he hasn't completed yet in the application process, whatever that might be. Okay. Okay.
Good to go.
Good luck.
Thank you.
All right, that concludes our informal appearances for the day. At this point, we're moving on to commission discussions. And you may recall 2 or 3 months ago, Ms. Taylor asked that a discussion on teams, and that was a general discussion topic, be added to this month's agenda. So at this point, we were on that topic, and I'll allow Ms. Taylor, if you'd like to just make any opening comments or thoughts you have, and let's just see what we want to do when we get to it, because it's a wide open topic at this point.
I just feel like there's so much discussion on teams, and especially when it comes to who signs the listing agreements, who signs the sales agreements, how it's advertised, and all of these seem to be issues that are unclear. And I think this is the perfect time to get that straight, where the public knows who's selling a house, who's not selling a house, and who's advertising, whose sign you see up there, who really has that listing. This is the perfect time for that.
So we're going to open this topic up. Ms. Franks?
Well, I had something brought to my attention yesterday, and I have a photo. It's of a in Franklin we have what's called live-work units, and so you can work downstairs, have your business downstairs, and you live upstairs. And this is a new development in Franklin, and there's a Keller Williams office there that it has the name of a team on it, but there's no firm license for Keller Williams in this subdivision. Those are the kinds of things that worry me, is, you know, when is a team a team? Just like today we heard, you know, when I had to ask, is it a team or not? Because they go by, like, Frank's team. So that's a real big question. And sometimes the teams have many, many people in them, and you may not even get to the realtor, the real licensee, until the closing table. So I think the problem is, and everybody's wanting to have a team now, and I'll start with, I'm not opposed to teams. I know there's classes for teams that teach them to be, how to have a good team. I'm not opposed to it, but I see so many times the principal brokers not overseeing things just like this. And so, you know, people send me stuff like this, and I don't know, am I supposed to send it to Malcolm or what to do? But I think there's a big hole in the bucket when it comes to what is legal for a team to do, and is the team leader in charge, or is the principal broker in charge? So I think somehow, I don't know how we get the message out about that, because, for instance, Keller Williams is the largest real estate company in the world, not only in the United States now. And so that is what they do. That's their model. And I'm not opposed to it. I'm just saying that somehow they've got to be held accountable, and not just Keller Williams. I'm just using them as an example, but they are the largest one that we have in the United States. Because I see so many people going out with their team names larger. I see it advertising, and it's rampant. It's not just, oh, I saw one today, I won't see another one until 6 months. It's rampant is what I would call it in the state of Tennessee. So, I mean, do we bring all these people in, Malcolm?
Well, I was trying to get the chairman's attention when y'all.
I know what you. I know. I was waiting until Ms. Franks was done, but I'm certain you have some comments on this, and you might go through that. So we're kind of directionless at this point, but we're talking generally about teams. You might want to talk about advertising.
Well, I was just going to make the case here. This is just one packet that I have received in the past 2 weeks. And what this is infractions of, or alleged infractions of the advertising laws having to do with teams and agents with inappropriately, you know, not putting the firm name and the phone number on the various things. And the majority of it is Facebook and Twitter. But what's interesting about it, I think there's also a debate having to do with advertising of what the definition is of prominent as far as the firm name and the phone number on a lot of these ads. I mean, Mallory and I had a discussion the day that I got this in, and, you know, we're trying to get our hands around it. But really and truly, I think you're dealing with two issues here. I think, one, you're dealing with broker responsibility, and the broker taking the responsibility in the direction of the team leaders. And then I think the second thing is a very strong education from the commission on what you can and cannot do within the advertising guidelines. Because obviously, as I said, I have a second packet, and this is just in the Nashville area. I mean, it's not even in Franklin. So, as I said, it is disturbing. And I think the other thing is, how do we go about opening, this it could potentially comprise of 60 complaints. And you may need to be looking at a different kind of sanction structure, just having to do with advertising, signage, which are some of your major issues that you're dealing with. Because if you look at your rules that you put together for teams, and you compare that to the other states that I have put together for you to review, you probably have some of the stronger rules in the nation. And so anyway, that's what I have to say.
Well, I have.
Can I interrupt just 1 second? So is your issue advertising as much as broker responsibility?
It's both, but I guess
Same.
it all starts with the broker to me. So that's where the buck stops. Is the broker.
Right, but your complaints or your observations are based on advertising you've seen.
Well,
yes.
Yeah, I'm just trying to get this focused. If we need to go to
Yes.
advertising.
well, actually not so much, because if you're getting a team contract into your office and the agent involved that signed the contract might be Jane Smith, and the team name is Mary Jones, they might ask you to remove Jane's name and put Mary's there. Now that we can't. That's a no MLS.
We got principal
issue.
broker issues, advertising issues, representation issues.
Right.
And I'm just trying to get them so we can keep focused
Right.
on that. Bobby. I'm sorry. Wait a minute. I'm sorry. Janice's next. I
Okay, go
interrupted
ahead.
her.
Well, I have a question for Malcolm.
Yes, ma'am.
If this commission directed you to just, if you get a violation in like that, would you need direction from this commission to say, okay, just send them fines, send them a civil penalty? If you get a violation, it's a clear violation. Why do we have to go to the trouble to open a complaint and go through that process?
Well, I think, and I'm looking at Mallory on this as well, I would think that if you change your sanction structure, you would have to create a set of rules having to do with cite and fine, or sanctions that in which we as staff actually sent out a fine system.
Don't you have some latitude in that now?
Well, there are civil penalty ranges. Like, there's a civil penalty range for rules. So anything that's in a rule, you can issue a civil penalty up to $1,000 per violation. The problem I see with that is that these rules have terms in them like the firm name and the firm telephone number listed on file with the commission must conspicuously appear on each page of the website. And the other one is the firm name has to be the most prominent name on so I mean, those are words that Malcolm and I don't know what you guys want that to mean. So I don't know that it would be appropriate for him or anybody else other than this body to be deciding those types of things. Now, there may be some are more cut and dry, like either the firm telephone number is on there or it's not. So that potentially could be something like that. But I think we would have to go through and hand pick individually which rules that the commission would want to have staff make that determination on, and which ones would need to come through the commission.
I would hate to see staff make those decisions. I think what we need to do, because this is the commission and we have the say, what I would like to see us do, for instance, on the advertising, is come up with some examples of right and wrong and send those out to the brokers and companies to let them know, okay, this is an example of prominence, this is an example of telephone, this is different options. and things that we see it in, they see it in black and white. Now that's only one part of this whole issue, but to have an example is very clear.
Well, but I think if the phone number's not on there, that shouldn't have to come before this commission for us to vote to issue a civil penalty. I mean, it's clear whether a phone number's on the sign or
Company
not.
phone number.
Or if the
Yeah.
letters are the largest in the company name, or the agent name. I mean, that's an obvious thing.
Well, to me, again,
It
I think
doesn't
we need
take-
examples
I'm going to jump in
before
on
we
this
do
one
that.
because this is one that Mallory she and I had a discussion on. Because half of these ads, the firm name and the phone number was on the bottom and not the top. So and that's when we got into the debate. I said, well, to me, the bottom can be as prominent as the top. And, we went back and forth. That's when we kind of did our hands up and said, we don't know.
Well, and on some of these websites, I think we have got to realize that we've got to have a little flexibility in the fact, too, that some of the websites are just templates, and all you can do is fill them in, and you don't get to choose this goes at the top, and this gets to be in this size font. So, I mean, I think we're going to have a little bit of flexibility in the fact that on my website, it may be at the top of the page, and at Marcia's, it may be on the bottom, but it's still on the website, on their webpage.
I forgot Mr. Wood. I need to go back to him, then I'll get to Mr. Bloom.
No, I'm good. I'm here. I started off on all this discussion thinking we needed more rules. And now I've come back to, I think we got plenty enough rules. I just don't think we're enforcing them. And there needs to be a quicker way to do it. I mean, our complaint mechanism takes a lot of man hours to do what we got to do. I would like to pattern it after these dang red light cameras, okay? Why can't you just take a picture of when somebody sends you this, you take their picture of whatever the violation or their yard sign and said, here's your sign. You didn't put the office number on it. It's $100. Send it back. You got 30 days. Otherwise, if you want to come fight it, we can come fight it. I think that might help correct the problem. Because I think the problem is now people are doing it, and brokers and people can say, you're not doing it right, but nobody's stopping it. And unfortunately, we have brokers that aren't strong enough to stop it in their own office.
Right.
And so I think we have to stop it. And I think we can do that. And I think make our fine on the lower end. It don't have to be this massive punishment. We're just trying to get everybody back and make everybody play by the same rules. And we're not doing that right now.
Mr. Bloom, thank you, Mr. Wood, for not yelling at me or anything.
You're fine.
Yeah, I think we need to get back to rethinking our decision, because we made the decision to say most prominent, thinking that we didn't want to build people's signs. We didn't want to make people's signs. We wanted the broker to answer that question as what's most prominent. That's the decision we made. And we may have made the wrong decision. I don't know.
So the words prominent and conspicuous are...
And really, I mean, what is it that we want? I mean, we want the name of the company to be larger than the agent's name. That, to me, is pretty cut and dry. And everybody should know that. It's been that way a long, long time. And then it has to have the phone number. Whether it's at the top or at the bottom, doesn't matter. The word prominent is where we've gotten in the muddy water. And maybe that word prominent doesn't need to be on there. Because what's wrong with it if the most prominent thing is a picture?
Yeah, and I've had that question too.
Let me go to Ms. Hills.
And to add to the team part, that I feel that besides advertising, all the things you've said, that's frustrating. I guess it's agency, and Commissioner Taylor hit on that. When you receive an offer, and let's just say it's from our trade association, at the bottom, because of copyright, it will have Janet DeCharo's name. And then as the licensee signature, it will have the team head of the team name. Then you receive it. You have listing. You receive it, and you have a question. Something's missing, and you call back. Who do you call? Do you call the one who's written up the offer, who is the one who showed the property? Do you call the one who signs the confirmation of agency, the purchase and sale agreement, and everything else, or there's a signature with that team head person's name? I don't know who signed it. Doesn't matter. So you pick which one you're going to call. Call one. No, I don't know about that. So they may give you a third person on the team that's now doing the processing. And those are the things. If I have trouble with that, being on the other side of a transaction from a team, how does the public even have any, how are they being represented if I can't even process something that way and understand how it is? So that's another thing I have with the team. So I guess it has to do with agency.
But I think also too that I don't want us to get down into too much minutia of what's going on and really how people run their business or what. I mean, we have all kinds of different kinds of models now. Everybody doesn't do it the same like we used to. So, I think if we want the name to be larger than the agent's name, that's one thing. If we want the number on there, that's another thing. But as far as the name on the TAR forms, and not everybody's a member of TAR using those forms, but I mean, we should know to go where to look for the agency name on that form. To me, that's a TAR problem too, because they've copyrighted those forms so that nobody's supposed to use them but that person's name that's on it. So that's their place to monitor that.
But I don't know who the agent is. I mean, the confirmation says it's
to me, it's whatever the confirmation says. That's who it is.
Who's not written the offer or showed the property. That's who.
That's who it is.
I know.
So let's see if we can focus on one piece of this. Mr. Horn, go ahead first.
Yes, let me show my ignorance first. What's a team? Now, wait a minute. I know it's, something they made up for sale. But do we have a definition of a team and who, how they should be constructed?
Nope, it's not recognized. The statute does not recognize teams.
Well, what are we doing?
Well,
they're functioning.
There's a reality that's in place.
That's one thing I think it's false advertising. When you advertise a team, you really don't know. A lot of the public doesn't know. And let's say the team is, and there's certain people like, okay, Fontaine Taylor. I just advertise under Fontaine Taylor. But let's say I have 5 people working under me, and they're showing property. I mean, they're agents, but they're showing property and coming back to me, and I'm using my name as for all of these transactions. The public doesn't know that that's not the broker doing that. They don't know that Fontaine Taylor has 5 different agents working under her to be selling all of this property, that people under her leadership, I guess, are doing that. So I think it's false advertising, and I think it's really opening a real can of worms here.
So back to your point just for a minute, Johnny. So nowhere in the statute is there any definition or rationale or approval of teams. None. But the reality of it is that there are teams in place in the real estate business. Last year, after a couple of years, we gave some guidance as to, well, if you're going to call yourself a team, these are some things you can and can't do. And so we're trying to work through that, and I think staff especially has found, and it's not hard for us to observe either, that there are some people trying to manipulate those rules or ignore them at best. And so that's why the topic keeps coming up. Even though it's not in the statute, it's in the marketplace, and we're trying to figure out how to handle it.
And I want everybody here to know too that so you understand why Johnny asked that question. We have 2 public members, and then we have 7 practitioners who are realtors. Johnny is a Baptist minister, and so he's not doing real estate every day. But the value is that he represents the public, and so if he doesn't understand that, that tells me the public's not understanding that either. So there lies part of the problem, I think. It's just a new term that people are using, but I don't think we need to get into telling companies how to run their business. I just want them to follow the laws and the rules in the Broker Act. That's what we are we wanting to make some new rules or what?
Just talking out loud, right?
Yeah.
Let's follow up on Bobby's line of thought for a minute. And he says we probably have enough rules, we just need to enforce them.
Mm-hmm.
So I can imagine from staff's point of view, somebody sends a dossier of 60 alleged violations. I don't know how you guys could present it to us without disclosing who the company or the agent is, for instance.
Well,
I mean, how would you make that presentation to us to a cry-like sign?
I've done it to you before.
Well,
I just described
not in masses like you're receiving now. I mean, if there's 60 complaints there, well, you have to open up a complaint against all 60 of them, or 60 examples.
Yeah.
And that's where I was going with.
I mean, if they're all different companies, which I think they are. I mean, if it's multiple ones against the same company, we could combine it in one complaint. But yeah, if it's 60 different firms, then it would need to be 60 different complaints.
But Bobby's right in that we need enforcement. That looks like enforcement. We've been begging other people, other realtors, to turn people in because we and so what do we do with this big pile of them? Then?
Well, it's not fair to all the ones who did comply.
That's right.
To then let people who didn't comply just skate.
Right.
I think they need the authority or need to know it's okay if the top person doesn't have a name or a phone number on there, and you pop a $250 fine in the mail and send it on its way.
I think they were saying that that's not really something that's allowed under our rules. Is that right?
Oh, I mean, we can do it. That in certain circumstances, like for example, with errors and omissions insurance, like that doesn't go through the complaint process. If someone lapses on their errors and omissions insurance, they just get a civil penalty, and usually they just pay it, but they can contest it if they want to. But we would, like I was saying before, we'd have to go through and like hand pick which rules the commission wanted to allow the staff to be able to do that for, because some of them are very subjective. Some of them are not, but we just have to go through and decide which ones you wanted to do that for.
Well, if we started out with if the company name, the firm name is not larger than the agent name, or as large, then that's easy. Seems like to me. If the phone number's not on there, that sounds easy to me. So why couldn't we at least give them the latitude on those 2 things? Because it would probably get rid of a whole lot of it in that stack. I don't want to deter people from not turning it in so it will be enforced. That's been the problem in the past. And not only that, the complaint sheet. I know we heard at the TAR meetings, the complaint sheets, those are too long and too big to turn anybody in. You know, I would love to be able to just call this person's principal broker and say, hey, you got a problem over there? But I'm not the real estate police. But somebody needs to call and tell them or say something. You know, do they not know?
Send them a civil penalty.
Right.
You've got to.
I mean, this is one that doesn't have a firm license. That ought to be pretty easy. So if they don't have a license, that's another thing you could do. I mean, that's a no-brainer, isn't it?
Let me ask a question though. If I'm my team and I don't have my company name big enough, is not only the company going to get a fine, the broker for not seeing that I had the right sign too? We would need to bring that into this discussion.
Well, that's failure to supervise, right?
Mm-hmm.
Yeah, it could be. Mm-hmm.
And we always
the broker
pretty much
and
do
the
that.
team leader, whoever the team leader is.
Commissioner Wood, Tell us again.
Okay, I think we're just being too stinking complicated on this. Okay, I'm thinking let's start and let's eat this elephant one little bite at a time, and let's just start taking these and send out a fine. Take the picture of it that we've got, send out a fine, and start doing. And let's just get the things that are obvious. We can get the obvious if they left off something off the sign. I think that is something that staff can look at and take care of and get it on out. And if we're having to get into determining what's prominent, what's not prominent, maybe that can go to a different category. And this is why we have to put prominent in there instead of just getting rid of that. There are people out there that have a lot more free time than we do. And what they do is they'll take their white sign and then they'll put the color of their name, let's say a gray scale, that barely has any gray in it. And they can make their company name this big, and then they'll turn around and make their individual name much smaller, but black with yellow background. Well, what's more prominent? You can't see the gray. That's why you have to do it, because unfortunately, there's people out there that just don't want to play by the stinking rules. And so, let's just make this thing simple and start something. And I don't have, and Malcolm, I'm probably going to defer to you. Y'all come up with an easy way for us to start doing this and not have to go through the process and get Mallory involved and her staff in it. Let's go easy and just start trying to reel everybody back in, because if people start getting fines, word goes really fast, and it doesn't have to be big fines. Okay, it just has to be something to reel everybody back in. And if the $100 fine don't get it, then let's 2 or 3 months. Let's go to $250. Let's just reel everybody back in.
Well, our
which is
minimum
kind of a wild
is
west right
$250,
now.
I think, right?
Okay.
Isn't our minimum fine $250, Mallory?
I think it's less than that. Let me see.
Is that a motion, Bobby?
Yeah, and I don't have any idea how to
It's
make that motion.
$50 is the minimum.
Let's make
Let's make it $250.
Let's do this. I want to try to keep this as specific as we can. So, and maybe we have to think about this a month, but staff would like to have, I'm sure, direction that says if an advertisement doesn't have the company's name on it, then staff is allowed to send an agreed consent to the licensee and to the principal broker for a certain amount of money for this particular topic.
Yes, but it had to be
What's
very
the advertising rule number that we would be talking about?
So, well, if you're talking about firm name just being on there at all, and telephone number being on there at all, that would be 1260-02-.123B. And just the first part, because the subsection 1 and 2 underneath it would require y'all to make a decision if it's anything further than that. With that being the most firm name being the most prominent name featured at the advertising, and then the firm's telephone number shall be the same size or larger than the telephone number of any individual licensee or group of licensees. So number 2 could potentially be one that we could look at as well.
So if there was an advertisement that did not have the firm name and or telephone number on it, then that would certainly be a violation of 1260.02.12B3.
Right. 3B, yeah.
Right.
Right.
If this commission gave you the authority to do this, you would be comfortable sending out an agreed consent offer to principal broker and the licensee.
Right. So what it would say, it would be similar to a consent order that you issue for complaints, where it would say, it looks like you've committed a violation of such and such a rule. You can pay this amount of money, or if you want to go to a hearing, you can go to a hearing, and then they can choose what they want to do at that point.
I think it would be good to send the picture of. That's what we're going off of, our pictures, and we usually like to have them date stamped too, don't we? In case they've corrected it a month ago or something.
Well,
they can argue.
Let me address that. When I got this in the mail, I did go online and look at a lot of this, and I would say 20% of them probably met our criteria and our rules, but they had not scrolled down through the total ad. And you can't just go by what's been sent into you. You have to actually go on the site and actually look at it.
Now, that's on web advertising, most of that.
Yes.
All right, well, let's just, if you guys say, hey, pay $250, don't do it again, it'll go away, they have the right to appeal that. If there's some mitigating circumstance,
They could come back for a hearing.
Yeah.
Well, what I would
Go through the complaint process.
What I would feel comfortable with is there are a couple of models out there that Mallory and I could look at and come back with a strong set of guidelines for you at the July meeting.
Be good.
Yeah, I think it would be best if we know that you guys are interested in having us do that for those two particular issues, like the firm name and the telephone number just existing on the advertisement, just letting us look into that and seeing how we need to implement it.
Well, and also the size. I think the size of the name is pretty obvious too.
But that's not
Well,
what
that's
the rule says.
the
It
firm-
says prominent.
yeah, it
The
says
size
prominent.
of the phone
It's a
number is the one
debatable
with size.
Now it does talk about the name being bigger than the
Prominent.
there is a statute.
Phone number is the one that's
Now hold on. There is a statute in addition to these rules. In the statute itself, there is a statute that says the firm name has to be the same size or bigger than any other name on a sign. So that only applies to signs. So yes, there is that in addition to these advertising rules.
I would also, if possible, like for you to look at the 1260-02-.12, number 2, A and B. What we see is the franchise name. So give me a franchise.
Century 21.
Century 21. And it's just Century 21. It doesn't say Century 21 of Kingsport. It's just Century 21. And so you can't go, that's not the name as registered with Tennessee Real Estate Commission. So there's not a DBA name that matches, and it doesn't have the other name. The name is with the Real Estate Commission.
Most of those companies do have like the Century 21 as the DBA. I've found.
It just says Century 21 is the DBA?
Right.
I don't think. I think they got something after the Century 21.
Like a word after
Yeah,
it.
like mine is Exit Select Realty. Mine is NYPD LLC DBA Exit Select Realty.
Many of the franchise companies have to have that each firm is independently
And that's a rule.
That's one of your rules.
Well,
But if
I know
just
that
have a franchise and they don't have any other way.
I know that the Keller Williams offices are DBA Keller Williams Realty. That's it.
But we also have a rule that says you cannot have similar names.
Well, I mean, we can't take names away from them after they've already. I mean, this rule was new, so I don't know how Malcolm's handling that now, with when firm license applications come in. But I'm just saying, I know from looking at all these complaints that most of these big companies with multiple, like the franchise companies, their DBA is just the name Keller Williams Realty or Cry-like Realty, without anything else on it.
I think they have the point of where we're going with this, and I would like to see them bring something back to us at the July meeting, something more concrete that we could vote on, because we could probably talk about this all day long.
So that's the advertising component. Back to Ms. Taylor for a minute. We may want to put this off till next month, or we may want to talk about it now, but so who is the public dealing with is her question. I think.
So they don't know who they're dealing with.
That was my thing on when you receive it. If I could figure it out, how did
And so, if that's the issue, if a licensee doesn't know who they're dealing with, how does the public know who they're dealing with? How do you solve that, or do you have a suggestion on how that should go?
Well, I was thinking about that, and I think that a team, if I had a team and 5 people under me, that any listing or offer I worked, it seemed to me I should have to put something in there that this person, Joe Smith, working under Fontaine Taylor. Now, Joe Smith, I understand, is working under the broker, but is a member of the Fontaine Taylor team and is therefore working this offer in the name of the real estate company and the team.
So that could possibly be a TAR form or something on the TAR contracts. Most I don't know of any companies who have like teams that are probably not members of TAR. There may be some, but I don't know
Well, I think
any.
I think there are some.
But so, I mean, is that a TAR thing, that if we could get them to add that to their forms?
I don't know.
Would that
We
help?
can certainly ask TAR, but we're the ones that make the rules, and then to me, it's false advertising if Fontaine Taylor advertises that I have sold $8 million worth of real estate this last month. Do you see where I'm coming from?
Well, and I personally don't see anything wrong with what you're saying, Fontaine. It's just like if I'm on your team, I sign Janet DeChara, member of Fontaine Taylor team or whatever, Taylor team.
Well, so let me
Something lines that big.
just a little bit of input on that. So most real estate companies, residential companies I know, practice designated buyer agency or designated seller agency. That means you get one license, period, one license. So if Fontaine Taylor is a team captain, whatever, leader, and she gives that buyer to one of her team members to haul around and show property and negotiate the deal, who is the member of the public working with? Who's the designated agent for the buyer?
It's whoever the customer decides is their agent.
Do you think the customer makes that decision, or does somebody just say, we're a designated agent for the buyer?
They've had
See,
to sign.
I only
bet
see
they've
what's
had
on the
to sign something.
confirmation. I don't see their agreement, and it's the team leader's name that's on the confirmation.
That's kind of the third leg of the stool as far as representation. So I don't think we're going to solve any of this today, but it's just, I'm just trying to keep us focused on what the topics are.
Well, and that's what you're saying is what we're having an issue with. One of our teams, after we made the team rules, just opened his own real estate company to get out from under having to have his broker oversee everything. He became the broker, opened his own firm, and now he signs every listing agreement, every buyer's rep agreement, and then calls the MLS and says, no, that goes under my name because I signed the buyer's rep agreement.
Ms. Kirby.
So we actually have a rule already that addresses that, and it says no licensees who hold themselves out as a team, group, or similar entity within a firm shall designate members as designated firm agents, as this remains the responsibility of the licensed firm's principal broker.
Which one's that?
That is 1260-02-.415, license under the licensees who hold themselves out as a team, group, or similar entity within a firm section.
So if you follow that rule,
Now we're on the same page.
so a broker appoints a licensee as designated agent for the buyer.
Principal broker, you mean?
Yes, the principal broker appoints a licensee designated agent for the broker. It's either the team captain or it's the person or some other person, but it can't be a combination.
Right. My understanding of that is once the principal broker designates the designated agent, there can't be any more designation after that.
Correct. You can't be sub-designated.
And that's also in line with the definition of a designated agent, which is in the statute, 62-13-102, which is designated agent refers to a licensee who has been chosen by the licensee's managing broker to serve as the agent of an actual prospective party to a transaction to the exclusion of other licensees employed by or affiliated with that broker.
Not that, just read the number.
It's 62-13-1027.
So many darn rules that even we can't keep up with it. I mean,
It's not the rules you're trying to keep up with, it's the licensees you're trying to keep up with.
So if I work for John and he designates me as the agent, I'm the designated agent, then I turn around and send Diane out to show the property, we're violating the law, which is what they're doing all day long.
Every day.
But it would appear.
And then they call the MLS and say, oh, no, put that under my name because I'm the designated agent.
I don't
And
think
the
that's a
person
violation
never
of
laid
law.
eyes on me. Do what?
I don't think that's a violation of law.
I don't think it's a violation of law either. It may be of
You
your
could,
MLS.
John could designate you, and you say, Gary, I've got to go to Nashville today to the commission. Could you show the property to these people? And I could do it. That's not a violation of law.
Well, but
When they do the
offer.
They may make it that day.
Well, that's a company policy. Who's going
Right.
to get credit for it? That's not ours to deal
Right.
with.
I
And who gets
agree.
credit for it over a long period of time at the end of the year is an MLS problem. It's not our problem.
I would agree with most of what you said, but it could be misleading to the public if John Grease puts out a sign that I sold a house every 24 hours in 2016.
Yeah, but there is a law, a rule with the with the National Association of Realtors, not for us, I guess, but National Association of Realtors, that anybody who was involved in the sale of the transaction can say that they sold the property. They don't have to be the listing agent.
With the consent, you have to have
No,
consent.
no, you don't have to. Anybody who is involved in the sale of the property can say they sold the property.
But that's not for us to judge at this point.
No,
TREC.
that's not even for us, because that's a realtor rule.
Our problem is the designating of other people and all the people filling out forms under one person's name.
Broker has the charge of designating who made the sale.
Right.
And the rest of that conversation is the broker and the other people involved. But the broker designates the person who's going to be the designated agent.
Well, and I think that's where we're having the problem. The broker's not the one designating them. The team leader is.
Well, then that's a violation.
Because the broker designates the team leader, and the team leader's been designating the 20 people underneath them.
All right. So we've identified the issues once again. And we've made some progress because we're going to have staff bring us back some guidelines as far as automatic sanctions if it's easy to determine as far as advertising goes. Ms. Kirby.
Well, so to be an agent of someone, you have to have the representation agreement signed, or you have to have the agency agreement. So I think probably what Gary's saying makes sense, that, you know, they can, if the principal broker designates the team leader as the agent, but then the other people do the work, I mean, if they had the agreement, if the team leader had the agreement signed, it doesn't necessarily mean the team members who were doing the work were acting as the designated agent, because they can't be the designated agent if they didn't have an agreement.
But they could, in fact, and they're not an agent at all, they're a facilitator. Would that be your interpretation?
Yeah, possibly. I mean, you could call them that, I
If the
guess.
agreement's with the team leader and they sub the buyer out, then the buyer's working with the facilitator at best, because there can only be one designated agent. So.
And that's the one I'm dealing with.
The public is dealing with somebody with no loyalty or obedience issues to that buyer.
That's who's responsible, is whoever's on that designated agency.
Right, but if they sub them out, that agency doesn't flow to the next, to the guy who's driving
The
the car around.
confidentiality and all that.
But so I'm at a closing, and we're all at the same table, or one party's getting them, and the one comes, the designated agent for this client, not my side, comes in. So nice to finally meet you. And you think, boy, there was agency there, wasn't it?
All right, let's try to wrap
That's
this.
a separate problem.
Yeah, well, that's the Fontaine
That's the
problem.
agency.
Yeah.
Right.
I mean, that's what we're talking about in that sense. Mallory, so is your charge for next month clear at this point?
In terms of the cite and fine potential,
Yeah,
yes.
those ones that are black and white kind of decisions you
Yes.
can make. Would you bring some guidelines back to us and
I
let
will.
us approve those and give you authority to do that?
I will.
Mr. Chairman?
Yes.
This may already exist, or it may not, but I think it would be helpful, at least to me, and maybe to the whole discussion, if maybe you could pull together the statutes and rules that govern some of what we're talking about on the representation issue, as far as what the principal broker has to do, and what affiliates can do and who has to designate what. And if we just had all of those together in one document, I know it would help me just instead of flipping back and forth in the book to all the different things. And I know where you draw the line on what starts to get kind of too tangential may be kind of difficult, but if you could just pull together maybe the things that are pretty clearly govern that issue, I think that could help kind of guide our discussion in the future as far as what rules do we already have in place, how do we enforce those, and are there more rules that are needed, or is something unclear, or what? I think that would help us in our discussion to have it all in one, the law all in one piece of paper about that issue of who is actually the broker, who's the agent.
Yes, I can certainly do that. And just another aside type of thing. I've never seen a complaint from a consumer dealing with any of these issues. The only complaints we ever see, and I've been here a year now, I've never seen one. The only time I've ever seen this is when agents are turning in other agents for this, and for the advertising stuff. It's all the same thing. So that's just something to keep in mind too, that, you know, the charge here is to protect the public, and from a complaint standpoint, it doesn't appear to be as big as a problem as maybe it seems like from the agent side.
We have had them, most of the team leaders don't fight it, and they just pay the penalty and be done with it, because I know there was somebody here last year for that very reason.
Oh, I know that there have been complaints, but they've just been filed by other agents, not from consumers.
Well, this was, I know for a fact that one was a consumer, because the agent told me what happened. So, it was before you.
If we believe these rules are to help protect the public, and some agents have to abide by them and some don't, it's natural that agents would say, let's level this playing field, I think. All right, let's move on. Mallory, we're going to go to education report and then come right back to you, the discussion of the proposed legislation, if you want to be ready for that. Oh, yeah, we have the youngest member.
Before I do the legislation, she has one case to talk to you guys about. I mean, we can do whatever you need to do.
I hate to keep the lawyers tied up.
John, what are we doing with this? Putting it off till next time? Is that what we're doing with this?
Coming back with recommendations.
Yes, on everything that we've talked about, not the advertising and the other issues?
I think Austin asked that you consolidate all the rules and laws that apply so we can maybe be more focused when we talk about it. Okay, please. So how long have you been with the Office of Legal Counsel now?
That's right, since February, so I'm
okay.
still new. I got to see you guys twice now, though. I really appreciate you taking time to hear from me, members of the commission.
Will you give us your name once more for the
Absolutely.
record?
I'm Sarah Page, and I'm not, well, now I'm not, well, I still am the newest litigator. We have some new attorneys up there, but they are not litigating at this point, so. I wanted to come before you with a represent on a matter that has two parts. And let me give you the facts before I tell you kind of what I'm thinking. In this case, the respondent is a principal broker, and on the legal report, he was listed for failure to supervise, and that's already gone down. He was failure to supervise stemming from the fact that he had an affiliate broker that's license lapsed while he was under this principal broker, and he was allowed to continue to work for quite a substantial period of time. In fact, it was from September 5th to March 9th, so from 2013 to 2015. So it was a long period of time. Yes, I can tell. But what ended up happening with this case is that a consumer complaint came in against the agent that was unlicensed. As a result of an investigation, it showed, the principal broker was obviously brought in as part of that consumer complaint for this unlicensed individual. As a result of that, it was put on the legal report, and a consent order was issued against the respondent, and he paid that civil penalty. It was $2,000. He also had to attend 2 meetings, and he did that. He signed the consent order, and he complied, and he came to 2 meetings. During that time, it was also discovered by the legal staff that there were evidence of the individual transactions by that affiliate broker. So we had one consumer complaint, but we also discovered, obviously from 2013 to 2015, if he was employed, he was working. So we only had the one before us with the $2,000 penalty, but we ended up finding through Mallory 4 more. As a result, I think was it this, I'm going to defer a little bit to Mallory, was it the same legal report that these were on, or was it different legal reports?
The first case was represented, and then this one, they were presented at the same time. But the first one had also been presented the month before.
Okay.
So, yes.
So, as a represent, the first consent order for $2,000 was approved by the commission and was signed. However, at the same time, for the same period of time, for the same unlicensed affiliate broker, there were just additional transactions that ultimately fell under a different complaint number. The reason that matters is because the principal broker signed a consent order that had language that encompasses the entire time period that we're talking about. When I first got this case, my first instinct was, why is there another complaint for the exact same time that he was punished? Granted, the consent order being a settlement agreement does not list all the individual transactions, but it's our experience in legal that that's never the case because these are settlement offers, and they're not intended to encompass every element of whatever the complaint stemmed from. It's supposed to encompass the major elements. On first reading, when you read the consent order, because the consent order the principal broker signed contains the time frame that this individual working for him, it is legal's position that this consent order preempts the bringing of additional charges. I think that the consent order in its own right, to be fully honest with the commission, it does have a carve out to bring in additional transactions and occurrences that might have arisen, but it's legal's position that this is not a positive policy consideration, and it would be difficult before a judge to survive a summary judgment motion if the attorney, which there is an attorney in this case, showed that this consent order, really on a plain reading, looks like it encompasses the entire time frame in all of these transactions. Because of that, I'm requesting that the second complaint be closed, especially considering he has complied and come to meetings, and it's always nice to have respondents that are compliant. So that's what I'm asking. I'm obviously open to questions, and Mallory has some insight on this as well.
And I think Sarah had mentioned it was failure to supervise. It was actually a different statute. It is unlawful for any licensed broker to employ or compensate any person who is not a licensed broker or affiliate broker for performing any acts regulated by the chapter. So that was the statute that he was found in violation of.
Thanks, Mallory. That's right.
Is that complaint in front of us this afternoon?
It is not. The complaint is with litigation right now.
Yeah, it was heard many months ago.
Not in Chancery Court now.
No, it hasn't been. It's in our internal litigation right now.
This is one where he's already been punished for having somebody working for him that wasn't licensed. And a new complaint came up, and we approved a consent order for additional punishment for having somebody working for him who wasn't licensed during that period. And you're asking us to basically reconsider that consent order that we already approved?
No, the consent order that you already approved is finalized. He's admitted to that fault, and the admission of fault is why I'm back, because the second group of complaints was discovered internally. They were not from a consumer. It was discovered in the pursuit of investigating what was already agreed to. So he agreed that he allowed this person to work for him and compensated him during a very specific time frame, and he agreed to that in the consent order in writing and signed it, a binding agreement. And then now we're coming back with the transactions from the exact same time period he's already admitted fault to and already been punished for.
And so what's the status of what you're talking about we're coming back for?
That's right now, because he recognized that he felt like he didn't understand at first why he was being punished again after he'd already complied. It came to litigation because he wasn't willing to sign the second consent order for additional transactions under the same exact time period.
So we did approve a second consent order to punish him again for the same thing?
Yes, on the same legal report.
Are you asking us to reconsider that and to basically withdraw that consent order and dismiss it?
That is what we are requesting from legal because of really the reading of the consent order itself. It makes it a difficult. I would never say that this commission is barred from doing that. I think that you are allowed, as evidence comes in and you find additional transactions, to pursue those transactions. But legal's perspective from a policy consideration, because of the wording of this specific consent order, it seemingly is we may run into an issue with their attorney as far as did we preempt ourselves within this consent order by containing that time period so specifically.
Mr. Chairman, I would move that we reconsider that and that we withdraw the consent order and dismiss the claim against the principal broker in the second matter.
Okay, a motion by Commissioner McMullen, seconded by Commissioner Horn. Do you want to give us a case number for the record?
Absolutely. The current complaint number is 2015-022008.
It's number 1 on the legal report.
Yes. So that's what I was asking, whether we had it today in front of us.
Oh, yes, sorry.
All right, Mr. McMullen has made a motion that the complaint file number 2015-022-008 be reconsidered. That's a separate motion. You just like to withdraw that consent order. Is that the right?
complaint,
Withdraw, dismiss, what should we do? What's
Withdraw and then close the complaint would probably be fine.
Withdraw and close. All right, the motion is to withdraw and close complaint number 2015-022-008, properly seconded by Commissioner Horn. Is there discussion on the motion? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
Thank you, members of the commission. Have a good rest of your meeting.
Thank you, Ms. Page. All right, education report. Mr. White?
Thank you, Mr. Chairman. Members of the commission, I call your attention to the Tennessee Real Estate Commission education agenda here for May 5th, 2016. I submit to you under the sponsor contacts that numbers M1 through M41 be approved after having gone through and reviewed all the documentations presented in the submittals for those courses and providers.
Is this May 5th or June 1st?
Oh, I'm sorry. I believe I'm looking at the wrong thing here. Hang on just a second. I was maybe looking at the last.
Well, that's what mine says
I was
too.
looking at the iPad. Sorry about that. That would be, thank you, Mr. Director. That is June 1st, 2016.
What number is that on the iPad? Number 19?
It is number 18.
The one that says
Education.
May 5th. It says May 5th on it.
That's incorrect.
Right here.
The correct, I have in my hand, the June 1st. I'm not sure. if
What
it's
is
on
what is the first course on it?
The first course is BAM Education Systems.
Well, that's not.
Let's see if it's on here somewhere. Hang on. Sorry about that.
Why don't we do this, Mr. White?
Yes.
Let's take a 10-minute break so we can be more efficient with our time. If you can locate the right.
I've got it in my hand.
We may need copies of it if we don't have the right thing on our tablet.
I'll go do that.
We'll be back in 10 minutes.
I think that's the easy way to do it. Office numbers on there. You send them a letter.
Well, I mean, Malcolm's got a stack. He told me he got 2 envelopes in one day.
Pretty smart. I'll make her. Oh, yeah, I think
Hello,
she
it's
was just
Gary.
confused by my question.
Clear violation.
She seems to be on top of it.
Yeah, I just texted Malcolm. No firm license.
Gas meter to the right of the front door.
Stuff.
Tell me your name again.
And it sure will help reeling this thing back in.
Yeah, because like you said, once
great.
people start getting fined for it.
No, just come back.
Thank you.
Pull out the gray out of my hair.
Well, I'd have to be pulling a long time. You had your lunch in your hair. You had crumbs in your hair.
Guess I was eating funny.
Could we just let those 4 violations skate? Is that what we do? I thought that's what we did.
Not that I know of. It's very unusual we'd have 2 different, fairly legitimate offers within the same month. Some of those are 40 hours. As I understand it, what I sent you today includes all 3 parts.
That's internal errors.
Yeah, but a lot of times they don't complain because they don't know they can
They
complain.
don't know until they have a problem.
Yeah.
And
No, no, because we'd have been approving something we didn't even see.
Janet, are you related to?
But he asked how you doing.
I was like,
But as you say,
I could still be like Bobby Wood Inc. doing business as, same name as your company.
Oh, yeah.
Bill relationship, I talked to him yesterday evening, was with Bill Thomas.
oh, wow.
And I don't know if he wants to park. You meet that someplace like. But I saw the offer was like $1,050,000, $120,000. Asked him about his buyers, and he works with different groups of investors.
I was a little bit quick on that answer.
It's sort of like a, sort of sounded to me like each deal different makeup of investors, which may or may not have one or two of the same principles.
So her mom got to the point where when she grounded Teresa and nailed the door shut so she couldn't get out of her room.
Let me mention this. I don't know him, but let me mention this to you. So when I talked to Taylor last week, I said, Dave, I need you to know that we've got a fairly informal letter of intent in front of Bob and Bill right now. He was almost beside himself. Apparently, over the last 2 or 3 pieces of property is going to require somebody else to show up. And by the time he gets the offer to him, it's already committed to somebody else. I could tell when I told him that over the last 48 hours, he received a letter of intent.
I'm the broker that doesn't.
He even said, I want to see this bug in my office.
Yeah, I got to see him all over the weekend.
You get Bobby.
So will you?
Now, to say that Bobby is.
Oh, actually, Marcia and I, we stayed last night.
But Dan, here's what,
But Marcia and I
argued
have
against it.
played out at 7:12
Bobby sells them.
Maybe I've been talking, maybe Brooks and I don't know, since the middle of last week. And it's possible that maybe Rob Evans was talking to her.
Verify.tn.gov, and they're all Century 21 something.
That's right.
Wait, hold on, I'm looking up something else, but now I'm looking that up.
It's like,
I thought that Keller Williams was all like Keller Williams, Nashville, DBA, the Dream Team. I thought they were all DBA, the Dream Team. Am I thinking of something else?
I can tell you how the hotel is.
about the Hilton in Scottsdale?
What's the middle line? Those two numbers add up.
That needs some more discussion.
But yeah, Marcia and I've got to be out of here by 4:30. It was clear. We may have to just go. We got to get out.
They had 400 for lots. More than 3. Oh, that's right. That's right. I had to plug it. I plugged Rob's board in.
Yeah.
That's right.
On and on. Doesn't stop. Johnny, you okay?
But appreciate you looking out for me, bud.
Did David Taylor's offer talk to the use at all? I just haven't looked at it up to it yet.
No, not usually.
Listen, I'm gonna call on the way home to Knoxville tonight. I'll call Brooks and tell him we got a set
The one that was up here a while ago, fast track.
Okay, thank you.
Broker, yeah. Okay, real estate firms.
Oh, I think you got your wish today.
We'll see. We'll see.
No, I think that could be easy.
Yep, I just read it all. I read this whole thing.
You and I may have to have lunch again tomorrow or next week. Okay. Every once in a while, I just have to vent. That's fine.
It'll still be about
He's taken. Austin, he's taken us 5. Allie got me to hire somebody. Yeah, she's actually a paralegal.
A real rotation on the agenda for July. Let's discuss.
Oh, on the trip stuff?
How to determine who gets to go? Just put us on a rotation. Okay. That'll be okay.
Look at this, Malcolm.
Back time, isn't it, Johnny?
Yes,
Gotta stay
ma'am.
away.
Yes, ma'am.
Verify.tn.gov of all firms under the name Keller Williams. Okay, I just read
Mainly it's
So, like this one is MEM2 LLC DBA.
Charge your wake up time now.
Then like this is Legacy Property Group LLC DBA Keller Williams 865, comma ///. Did the fill just end there because it was out of room or what?
I don't know.
This
Oh, man,
was
how about
Kristen Waltney,
That's Southern
Team
Chivalry
Keller
there.
Williams Realty. That doesn't have a DBA on it, it doesn't look like. This one is Knoxville Properties DBA Keller Williams R.
That's the big
probably means Keller.
I put in Keller Williams yesterday just to see what I was, because I was.
That's the same search I just ran.
I actually read it today. Some of it.
License.
I actually followed on through what they was talking
Keller
about.
Williams, your people?
No, Steve.
Because that was the kind of out of my element.
Listen, hey, I was on professional standards for CRV and we developed a course for teams. I was on that committee, so I'm not against it. Like everything else, they just won't follow the rules. They want to do it their own selves, but they
Were you in the work group with Nick Ambrosia? I got an email from Adorna this morning.
So Bobby, I have two
Adorna
thoughts.
was
On your thing about like
Yeah,
what if
because she gave
what
me a
if-
few names.
So what was your situation? You were talking to Gary and you were like, what if I named my firm?
Took her 10 days to get back to me. But I got a little hook going now.
So his
does more
is
teaching
Gary's Properties.
than- I don't even know if she does real estate.
And
She just-
DBA Gary's Property.
I really like her.
So I
Some
got two
people don't
thoughts
like
on
her.
that.
She was like-
One,
I got to know her
maybe
better in
it's
this
somehow
business.
a
No, I can-
violation
you-
because
smaller
of
group.
what
You and her
Tank
would
was
lie.
talking about that it's deceptive.
Because she's direct.
But on the
And
other
she's a
hand,
cheerleader, and so am I,
maybe
so.
it's
No,
okay.
she and I are
because
very
I'm thinking
good
from more like a
friends.
property kind of perspective, like he kind of
Say
owns
Keller
that
Williams was
name.
the biggest in town.
If he agrees to let you use the name, then there's not really like
Yes,
property kind of, you're not stealing property from him. On the other hand, if he didn't want you to use it, he might be
She
able to
was in
sue you
Washington.
to say
And
that
I
you
was
stole
to leave,
his
and I was there
property
another day or
somehow.
two, so.
But
I need to call her.
so like
again.
on a
It was
franchise,
good to have that connection. I'm
they
so
were
glad
if
that-
all the
She's a great
Keller
lady.
Williams
Yeah,
people
I
pay
liked
some kind
her.
of fee to be able to use that name, then from a property perspective, it doesn't seem like there's really an issue. But maybe there is from a
All right, there may have been some of you wondering during our last discussion how come we're spending so much time talking about it. Couldn't we just solve it ourselves? We just don't have the latitude of talking amongst ourselves unless we're in a public forum. It's called the Sunshine Law. So sometimes you will think we're wearing a topic out, but it's the first time we've been able to talk amongst ourselves and try to understand or see if there's a consensus to go forward with a particular topic. Ross is getting his copies. Here he comes.
Yes, sir.
Here he comes. So, Mallory, while we're waiting on this report, let's talk about proposed legislation. We can
Okay.
dual task here.
Sure. Let me grab my paper here. So last month, the commission, it sounded like it was pretty much unanimous that the commission wanted to propose legislation to eliminate the grandfathering clause. So before I submit that as a proposal, I just thought it might be a good idea to take a vote on that, just to make sure that there's a majority of commissioners that want to propose that.
Who are you submitting it to, Mallory?
So we submit it to the department's administration, and then the administration looks at all the proposals from all the boards and commissions and all the different divisions within the department, and then decides which pieces of legislation to propose as part of the department's package.
So, didn't we talk about 3 or 4 different topics, potential legislative issues?
We did. We talked about a few different topics. I think the only one that the commission really had a solid interest in, like, specifically doing was the grandfathering. But we can certainly talk about any other ones you want to talk about as well.
Do you recall what those were? One was unlicensed activity.
Yeah, that was mentioned. I don't know that anybody specifically proposed any particular legislative change. If somebody has an idea, we can certainly talk about it.
What were the other 2 topics? Do you recall?
I think one of them was the LLC issue, about how that is not currently included in the corporation exemption, according to the Attorney General. I think those might have been the only 2.
3 then?
I think it was just the 3, yeah.
Okay. Okay, so the floor is open. You want to start, Ms. Franks, with the grandfathering issue?
Yes. Today at 4 o'clock, Janet and I have to leave to catch a plane to go to an Arello meeting. And Arello is all of the commissions, or most of the commissions in each of the states have this group that comes together, and we talk about mutual differences, things that have worked, and it's a group where we try to be better commissioners together. And on my very first meeting, we were sitting around the table, and I said, let's talk about grandfathering. How many of you are having trouble with grandfathering? And they just looked at me and they said, we don't have grandfathering. You have grandfathering? And I said, yes. And I think Alabama at the time was the only one that had grandfathering. And so we got to looking at how many grandfathered people do we have now, Malcolm?
There's possibly 5 states that still have
I'm
it.
talking about in Tennessee.
Oh,
Like 6,000.
yeah, it's probably a good 6.
So about
6,000 to
6,000
7,000
people in the state of Tennessee are grandfathered. I am grandfathered, and what that means is that we don't have to take any more education. And especially for principal brokers, if anybody needs to keep up, it's principal brokers, and you can't do that without getting education. You just can't, because we can't even hardly keep up here, and we come every month. I just believe that the grandfathering is a terrible idea. It's not something that we voted on. The legislature is the one who decided, and the date has been moved several times. We're now up to anyone with a broker's license before, is it 2005? 2005 are grandfathered. They don't have to have any education. And the problem has come that if anybody comes up here and they're in trouble, then their principal broker most likely is going to be found guilty of failure to supervise. And so they're in trouble too. And it's why I like to ask principal brokers, are you grandfathered, and what's the last class you took, and when did you take it? Because a lot of the time they can't tell us when the last class was or what they took, because they're not doing a lot of education. So I just see this as Tennessee is being left behind on this. Most states, Kentucky just increased their education requirements from 16 to 64 hours for affiliate brokers. So everybody's looking at it as we all need more education. You just cannot be a realtor and not get education. So this has really been a pet peeve project, whatever, of mine, in that I would like for us to be a strong voice as the Real Estate Commission to be able to send to our legislators who make the laws and who pass the laws that we are against grandfathering because we believe in education and that we want all of our principal brokers especially to be educated. So that's what we're talking about here now, and I'll let the others speak to it.
So, just to be clear, the Real Estate Commission won't lobby the legislature.
No, if the department decides to include it in the department's package, then the Department of Commerce and Insurance would be the one advocating for it.
So a motion that would please Ms. Franks would be a motion to encourage the Department of Commerce and Insurance to advocate for removal of grandfather.
So legislative proposals can be brought in different ways. They can be board authorized. So like the commission votes on a proposal that they want as a whole that they want to see proposed, or administration can propose things. So basically, I was just asking for the vote just so that I can, when I take it to the administration, I can say this was approved by the commission, like they as a body want this. That it's not coming from me or Malcolm, it's coming from you guys.
Okay, so Marcia, if you'd like to make a motion.
So I'd like to make a motion that we agree that we are opposed to grandfathering, and we would like to see grandfathering taken away in the state of Tennessee.
A second.
Okay.
Is that for brokers and affiliate brokers? Because there is a grandfathering clause for affiliate brokers that goes all the way back to 1980, but.
Well, didn't know about that one. So yes, for both then.
For everybody.
For all grandfathering in real estate. Gosh, I didn't know about that one.
What other questions do you have, Ms. Kirby? Okay, you've heard the motion. Is there discussion? Commissioner Horn.
Yes, I need to ask the question. Does grandfathering, is it only concerned with education, or are there other implications?
It's just education. It makes them not have to have, they're not required to have any education.
Well, I understand what we are doing here, but I'm just wondering, is there any other thing attached to it? It's just education.
No, just education.
Thank you.
Commissioner Bloom.
Yes, I'd be for this if we had an advocate speaking for us, like Russ Farrer or Chris Sexton. But you take this proposal to the legislative floor, and it's going to be beat down, because the legislators are the one that enforced it. We didn't come up with the idea. The legislators did, and the legislators are going to say no.
I feel pretty sure that the TAR, I haven't talked to Russ, but I have with Chris, I have with Steve McDonald. I do think that we can find an ally there that can take it up for us. And I'd be happy to speak to Russ about it if I need to.
What's the, you said the date is 2005 right now. Did it used to be earlier?
Yes.
I bet they moved it.
Yes, it's been moved a couple of times.
I don't think
That's
they
just
ought to
for
move
brokers.
it, but I sort of feel like once you've got people who are grandfathered, it's kind of hard to take that away from them. And so that would be my concern. But I certainly think they ought to stop moving the date back. I mean, once we grandfather these people, we ought not grandfather more people.
It's going to take a long time for 6,000 people to die, though. Die off.
Actually, there's more than 6,000, Marcia. That's just people who have a broker's license. It's over 6,000. And, you know, it was 1980, and that was okay, because like Wendell used to tell me all the time, we're going to die soon. And then they kept moving it, and I certainly don't think any principal broker should ever be grandfathered.
I wish they would have just left it at 1980.
Yeah. But as more of them got their license, then they moved it up so that they didn't have to.
And it should show something that we are a very small minority of states thinking that it's a good idea. If we vote against it, then it's saying, oh, it's okay, no education. So, I just think that it's too important to not go forward with it.
So I'd like to just speak in general terms to reflect what Commissioner Bloom has said. and what Commissioner McMullen has implied. I understand why you want grandfathering to go away, but practically, I'm not sure that's an issue the state of Tennessee wants to wrestle with. I'm not sure it's an issue that the Tennessee Association of Realtors wants to wrestle with, because there's a big group within the association, the trade association, that does not want grandfathering to go away. And so we could send this up with all good intentions, but it could either put the administration in a box or cause the administration to say, we're not going to handle that, which would be kind of a slap in the face to the Real Estate Commission if you took it that way. So
I'm willing to take a slap. I'm willing to send it up.
I'm not trying to argue against you voting any way you want to.
I think we have to have courage and do this.
Ms. Kirby.
So the department gets proposals from a lot of the programs every year, and they pick a very small percentage of the legislation to actually include in the package. So if they don't pick it up, that's not because they don't think it's a good idea or because they don't think that it's a good policy to have. They have the department administration has different reasons for why they pick certain pieces of legislation over others, and some of it has to do with like strategy of how well they think it'll do on the floor over at the Capitol, or if it fits into one of the governor's priorities. That's kind of what the administration has to look at too. So it doesn't hurt anything by just saying you want to propose the legislation. I mean, the worst that can happen is they say, oh, we're not going to pick it up this year, and then you can try again next year, or if TAR wants to do it, they can. So there's really isn't really a risk in just saying you want to propose it.
Starting place.
Mr. Bloom.
Well, if there was a priority, I'd rather address the unlicensed activities. We cannot do anything with somebody who's practicing real estate without a license. We are handcuffed. We cannot do anything. I'd rather do that, something that we could do forcefully for the licensees and the general public, because this is going to drift around there and nobody's going to do anything with it. I agree. I mean, I'm for the removal of grandfathering, but I just think we're blowing in the wind.
We have a motion on the floor to start with, offered by Ms. Franks.
Another question.
Yes, sir.
Have we ran this by any congressman or senator?
Oh, every time they see me, they're hearing about it.
Me too.
Oh, I don't mean that just to throw it in their face, but somebody that we can pin down who may understand what we're trying to talk
Well,
about.
and there's realtors also that are in the legislature. And so those are the ones that I've been zeroing in on, and especially the ones in my community.
I like to try to zero on those who's not doing anything, who have not passed anything in the last couple of years. And I know about 2, 3 that their name never appeared anywhere. They might want something to do,
Like that.
Okay, so we're going to vote on Ms. Frank's motion, which might be one of 2 ways to get this done. The trade association can handle it, or the state may handle it. Okay, we're just taking one avenue, proposing it. It's nothing significant if it moves up the ladder or if it does not. Are there any other comments on this? So the motion is to encourage the state to ask the legislature to remove all grandfathering that's related to education in the real estate industry. Let's vote. If you're in favor of that motion, vote aye.
Aye.
If you're opposed, no. No. The motion passes 7 aye and 2 no. Chair votes no too. Not because I'm against the effort, I just think the practicality of it is.
I'm calling Judy.
That's all right. Judy's grandfather. No, she's not either.
She's against grandfather. I'm calling Judy.
All right, now let's go to unlicensed activity, Mr. Bloom. Would you like to propose a motion that we encourage the state to give us some authority to regulate unlicensed activity?
Oh, I'd love that. What you just said.
Is there
I'm not really sure what you mean. Like, we do have the authority to do that, so I'm not really sure. I mean, we
Cease and
How do we
desist,
collect?
don't we?
right, and we issue civil penalties, and we can refer them to the DA's office. All that's already in our statute.
Oh, yeah, but you refer to the DA's office for $1,000 complaint. They're
Right, that's why we generally don't do it, because the DA's office
Yeah,
doesn't
that
do anything
falls
with it.
down to
But
him.
we do issue them civil penalties.
But we can't take a license away, for instance, if they don't have one.
Yeah, I mean, I don't know what you could possibly propose that would allow you to do any more than we already can do.
Oklahoma has made it a felony and they go to jail.
Well, I mean, it's already a crime in our statute, but just the same thing. Like, if you send one unlicensed complaint to the DA's office, like, that's going to be probably not on their priority list.
That's almost universally true, don't you think?
With what?
I mean, any citation we send to a local district attorney for unlicensed activity is probably going to go to the very bottom of their stack of things to do.
Probably. I mean, I can't speak for them, but
I know, but
I
they've
would
got a lot of other
anticipate
big
that.
issues.
Right.
But again, to me, it's the same premise. To do nothing is almost saying we don't care. If there is anything, even if it's just a comment like we just made on grandfathering, that's really all it is a comment. I think we should make a comment about this also and run that up. Maybe the governor or his staff would see some merit in that and run that. Whether they had to pick one or the other, they're both important.
Mallory, what might give teeth to that proposal?
I mean, I'm not really sure. It's already a crime in our statute. It's a misdemeanor, I believe. I would have to find the statute specifically, and we can already authorize civil penalties for them. So other than that, I'm not really sure what else could possibly be done.
Do we need any kind of legislative approval to increase civil penalties for certain violations?
Yes, that's not in the broker statute. It's set by administrative law. So, yes.
What is the crime? I mean, what would that be called if someone was arrested? What's the crime called?
Unlicensed
activity.
Yeah, unlicensed practice of real estate.
Okay.
I'm willing to think about that, because I'd like to have some teeth in that when we come up with a proposal.
Maybe Lady Cinderella, if you guys would just ask what other states do as far as unlicensed activity, as far as penalties, that might be helpful.
Yeah, I mean, if they have something that I just can't think of, then if you hear of something, just
We'll talk to
let us know.
Oklahoma while we're out there.
Yeah, see if
Okay.
you can get us some.
I just don't know that making it a more severe crime would really be all that helpful for the same reason that we don't prosecute many unlicensed people now. So.
But I hear, not to beat this horse, but for instance in Memphis, I hear there's a whole bunch of unlicensed activity going on. I know there is in East Tennessee, in farm and lake property. There are people that are out there, and maybe it's the definition of what they're doing, but it could be optioning property, then flipping the property where they never owned it and taking the profit on it and paying themselves a commission at the same time. I mean, there's a lot of that goes on that occasionally hits and is a big ticket to somebody. So you might not hear a lot about it, but I think I hear a lot about it.
Well, I mean, if we get complaints like that, they'll be disciplined for unlicensed activity. I don't know that it's a matter of like doing a legislative change, more so as we just need to know about it so we can address it. Because like the hearing that's going to happen on Friday in front of an ALJ only is unlicensed activity. So, I mean, these are coming in. So.
Is there a way to simplify the complaint process?
Activity or
for anything really?
Well, I think that's what you've empowered us to come back with you to in July.
That's for specific things.
Yeah, generally speaking, no, because you have to give a respondent the ability to respond. So in order to do that, we have to send the complaint to them, give them a reasonable amount of time to respond, which in our statute is 10 days, and then it has to be presented. So I'm not sure. I mean, definitely take any ideas you might have, but I'm just not sure how.
I just know
it
somebody
could
at
be.
TAR said the complaint was way too long to fill out.
Complaint form?
Mm-hmm.
Yeah.
I mean, I don't think so, but I'm not sure. I mean, it just asks for basic information like your name and your email address and your address, and did you contact an attorney and describe your complaint, and do you attest that this information is true? I mean, that's basically the gist of the form.
It doesn't have to be notarized or anything.
It doesn't have to be. We like them to be. It says in the letter they get that we'd like it to be notarized, but it's not required.
And can they do it anonymously?
Filing a complaint?
Mhm.
They can.
Okay.
Okay, the third legislative topic had to do with this LLC issue. Is there any direction requested by this commission related to that topic? Would we like a piece of legislation that definitively says who can represent an LLC? Or who
I think
must-
we talked about that in Jackson, didn't we, a little bit? And I think because I know when I first heard about it, I was on this commission. And so I take it home, and my attorney's like, well, that's not how I interpret that. And I said, well, we have the Attorney General's office opinion. And I sent that to him for him to even realize that, okay. But I think it needs it needs to be very specific. He thought there was a lot of ambiguities in it that he could defend.
So I'm not really sure what the right answer is, because essentially we could include LLC to be in that corporation exemption, but that wouldn't really solve most people's problem, because that's a very narrow exemption. If it's a very narrow set of circumstances. Most people that I think that at least that I'm seeing in complaints and the questions that I get from consumers and attorneys is individuals who have maybe like a single member LLC, or maybe there's a couple of members, but it's a small LLC, and they buy and sell properties, and they think, well, these are my properties, and so I can buy and sell them without a real estate agent, which is not how our law is written. And so, to me, when I look at the statute, it seemed like it was probably the intent of the legislature that anybody who's buying and selling real estate as a profession needs to have a license. And a lot of these people who flip homes and stuff, that is their profession, but they think that they own their properties in their LLC, so it's their properties and they don't need a license. I think that's where we kind of get the confusion. But I don't think adding the LLC to the corporation exemption is going to help that set of circumstances. So I'm not really sure how to solve the problem. It may just be something we need to be thinking about in the future, but just wanted to throw it out there.
Like if some LLC owner doesn't like the Attorney General's opinion, they ought to be the one to go down and lobby the legislature for the change.
Works for me. Other thoughts on LLCs?
I don't see a practical reason why LLC is not included as part of the corporation exemption. So for practicalities purposes, I think it may be a good idea to ask to include LLC in the corporation exemption. But again, that doesn't address the bigger issue. I think that just cleans up a little issue.
I was asked someone with the LLC that advertised, we will buy, we will sell. If you find yourself in a difficult situation, we can take care of your real estate needs and things like that. And that's what they thought. So I don't know that including them in the corporation thing is a benefit without having their license.
Right. It sounds like, without knowing any more details about this person's business, it doesn't really sound like that would fit in the corporation exemption. The corporation exemption basically applies to if you have a corporation and you have an employee, let's say, who your corporation has assigned to dispose of a piece of property. They can do that without a license as long as they don't get paid based on the transaction at all. They don't get a commission, they don't get a dividend from the corporation that has any of the value of the money made from the property included in that. It can't be connected at all. So I don't think, like I was saying, I don't think that applies to very many situations at all, because most people do real estate to make money off of it based on the sale.
But if they included, I thought you said if you asked about them including the LLC into the corporation exemption.
Right. So that would apply, the thing I just described would also apply to LLCs, which right now it doesn't. So like say you decided to make your company an LLC instead of a corporation, and you were doing the same thing, like you had a piece of property and you had one of your employees go and sell it for the company, they didn't make any commission, they didn't get any dividends on it, then that would allow the LLC to be treated the same way. Because right now that only applies to the corporations.
Okay, other discussion on proposed legislation. Valerie, are you okay with what we've done or not done here in the last half an hour or so?
Yeah, I'm okay with it.
Okay,
It's good.
just want to make sure. Make sure. All right, let's go back to the education report for a second. Ross, thanks for getting the revised data to us.
Thank you, Mr. Chairman, members of the commission. I'm sorry about the little snafu there, but we have it in front of you now properly. Pages 1 through 7, and it's courses J1 through J41. I would submit those have been properly reviewed and are ready for your review and approval.
Question for you, Ross. Are these all expiring at the end of this year, since this is the education year?
Yes, ma'am.
I'm kind of surprised you're getting this many this late in the year.
I agree. It was pretty tough getting them ready this time.
I make a motion, we approve courses J1 through J41.
I have a question.
Okay.
Let's see, on page 3, the second one down, about smart home technology.
Yes.
I'm wondering about this one. Does this person, are they selling smart home technology, or what's going on here on this one?
Well, they have a class that they put forth to teach, and they've taught other realtors, and not realtors, they've taught other contractors and those, I guess, in the business, inspectors and so forth. And this gentleman has a very good background as far as this type of technology and home security. So what he presented is essentially, what I read through and looked over, and it looked proper, and it is something now that realtors want to be concerned about or considering. As the smart home technology has taken off in the last couple of 2 or 3 years, it's innovative, I guess, to some degree, but it's becoming the norm in many places.
So is he going to be selling his system? Is that way? First of all, does he sell smart home technology?
Yes, he does, because here's his credentials.
Okay, yeah, I'm looking at it. So,
I saw that, but at the same time, I just looked at what he was presenting, and he is somewhat of an expert in his field.
does it open the door to ADT and everybody else?
He's properly licensed through the Alarm Systems Contractors folks, so I'm not. How AT&T it could, I guess.
They could if they write the class.
That's correct.
But he's not taught any classes with us before, right?
Oh, man,
Okay.
It was new.
Okay.
All right, we've got a motion on the floor offered by Commissioner DeChara, seconded by Commissioner Horn, that courses J1 through J41 be approved. Discussion, Ms. Hills.
I also have a question. That was one of the ones I flagged to question. The other one is on page 4, and it's sort of the same line, and so I guess it's the home inspector group.
Which one, Diane?
Oh, I
The
mean-
managing the home inspections, is that the one?
Well, just any of those. I mean, comfortable with them being 2 hours, and lead testing, I can see that, mold and sampling.
Well, agents are just opening themselves up to more lawsuits if they are setting themselves out as an
to
expert.
being knowledgeable on
But
it. I
I
guess
think that-
that's my thing as a broker, but you have to have, the public does look to you to have some
Yeah, and
general
I think
knowledge.
it's good if they have some knowledge about it.
Well, they've got a lot of classes written for it.
Yep.
It was a most extensive inspection-related thing I've seen in the last year and a half.
So, just to follow up on that, the very last course in that set of offerings is a 3-hour course on electrical inspections. I don't want to know more than about 5 minutes worth of electrical stuff.
Me either. I don't know want that. And what are those qualifications for someone to teach that?
Well, we're not, well, we're going to get to the instructors in a minute, but just the course itself, can somebody teach me for 3 hours about electrical inspections that, I don't know.
I have a question to ask too. I think that, first of all, going back to the smart home technology, I would hope that any class we teach is not a sales pitch, and that is not that they cannot sell a product at our classes. I would hope that. To which I think we as a Tennessee Real Estate Commission should know that realtors should always be kept on a contention with me. And then I think that we need to be really very careful about giving these classes on electricity and stuff like that, because, I mean, one of the main things we do as a real estate agent is sign a disclaimer form that we know nothing about anything, basically. And I think we are opening a can of worms if we get too technical on electrical and plumbing, and because we're not qualified even if we took the course.
Those
to
items,
answer the questions.
Those
yeah.
items are latent defects in my mind. I don't want to.
Yeah, that's for a professional to tell to somebody. That's not for me to say.
But do you need a class on structural inspections? That takes a structural engineer, and I always, if it has to do with law, I get a lawyer. If it's a structural engineering, I get a structural engineer. Same with electrical.
That's exactly
I'm a little
what I'm
worried
saying.
about, you know, and this person, what are they? There's only one person on these classes, so I'm wondering.
Here's his,
Does he have any other classes with us, that company?
No, he's, you,
Okay. So he's a home inspector, but he's not a specialist in engineering or electrical or anything like that. So how do you write a
Inspection,
class?
They say they don't know much about anything too.
well, you write a class. That don't mean you're an expert in it. That's good to know.
Wow.
All right, we need to keep moving forward here.
I write a class about lots of stuff.
While we're going, I need you to teach me how to
The
write a
rule
class.
says that we shall approve a course if it's directly related to construction, property condition, or energy.
All right, the motion on the floor is to approve courses J1 through J41. Does anyone wish to exempt any of those courses before we vote?
I'd like to exempt on page 4.
Deals with
So Austin, would you say again what you found, please?
Rule 1260.05.03 5A. It says the content of all courses approved by the Commission for continuing education shall be directly related to the following topics. And one of the topics listed is construction, property condition, or energy.
But you think structural inspections and electrical inspections have to do with, you know, my husband's a contractor. He doesn't do that himself. You've got to have a license to do those things.
well, I don't think this is going to teach you to get a license.
Okay. Well,
I mean, it's going to teach you to better be able to communicate about it.
okay.
All right, further comments? Mr. Horn?
I think what they're trying to put out is that you need to know when you have a structural problem, and to get it certified, you have to have somebody who is certified in that field. Of course, I do electric. I'm not licensed, but I was a missionary, and I went through the schooling that they go through because of church and state I don't have to have a license, but state of Tennessee can make me come down and prove that I know what I'm doing. And that's something that they have continuously on any skill field, that they can call you in and say, well, okay, you said you know this, you know that. Here you go, prove it. And I believe that it would be good if I had structural damage to know that what I'm looking for, electrical problems, the grounds are loose, so the fuses keep blowing, and this type of the circuit breakers keep blowing. I would be able to tell somebody what's happening there. And I just don't see, because they can't teach you enough to kill you. Because you should leave it alone if you don't know what you're doing.
Screwdriver on the live wire.
Good point, Mr. Hartman. Mr. Char also made a good point. This course is only good through the end of this year. All right, the motion is on the floor to approve J1 through J41. Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Now, Mr. White, regarding the instructors.
Yes, sir. I was pointed out by the Executive Director Young to put forth something involving a background on each instructor, and I tried to do that for this meeting. And if this is the form you want it in, you want it changed in some manner, I'd like you to let me know. But basically, I took the credentials, what they're all about, what they're doing, when they were licensed, if and when, and what some of their basic credentials are, and then put them all in this sort of a bio on each one.
And I do appreciate it, because I have asked for this several times. I like to see that they're qualified. I will tell you to save yourself some time on the ones we previously approved. I don't think it's necessary that you have to give us their credentials over and over again. But I do appreciate what you've done on the new instructors. And
Very good.
I would make a motion to approve the instructors.
Second.
Motion by Mr. Char, seconded by Ms. Hills, that the instructors listed on the June Education Report be approved per the recommendation of the Education Director, Ross White. Mr. Bloom.
Have they all been through the course that Marcia Franks took recently on instructors?
Some have and some have not, but
Wasn't that a requirement?
essentially they've all taken or are taking the manual that's on our website, which is an alternative at the present time.
Oh, okay. So they've all done one or the other?
Yeah.
Okay.
Have you seen the manual,
No,
Mr. Bloom?
no.
You need to.
Can we talk about that a minute after we vote on this?
Sure. We might have to amend the agenda to accommodate you. All right, let's vote on
Just a short
on the motion to
conversation.
approve the instructors. If you're in favor, vote aye. If you're opposed, no. Motion passes unanimously. Mr. Chara.
I'm not real comfortable with the online training manual for the Train the Trainer course, type courses. Ms. Franks pointed out that she just recently took that course, and I think she would tell you there's a lot of value of being in the classroom and learning from those instructors. We have one of those instructors in our presence today who does an excellent job at that. I don't like that they can take an online course to teach classroom classes.
And it's not even an online course, it's just a manual, you can
Yeah.
look at it or not. I think we need to put some meat in this, and what's wrong with requiring them?
I think they should
To
have to
have
go to the
that course.
classroom. Or have the other qualifications.
And there's a lot of people who think they can be teachers, maybe because they taught Sunday school or something. But I know in our class, we had a great guy in our class, and bless his heart, he drew number one. They had to be the first person, because we had to get up and we had to teach a 10-minute class. And he was a great guy, but he got up there and he just froze. And he couldn't remember a thing about what he was going to say. And so it just crushed all of us because we liked him so much. But, I mean, just because you think you can be a teacher doesn't necessarily mean you can be a teacher. I've wondered that about myself for a long, long time. So I think taking that class will kind of, I think it helped a lot of people in that class to see, I'm not cut out for this, or I am.
So, is there a desire to put something on next month's agenda related to this?
I would like for us to talk about it next month, and to everybody think about that, and
Just tell me the topic in about a sentence or two.
Online or correspondence training course for instructors.
That's one thing, but the other thing is requiring the class.
Okay, how says education required for instructors?
That's the
That's
topic.
good.
That's the topic
That's
for next
good.
month's agenda. Okay. All right, Ms. Kirby, the rulemaking process we're involved in.
Yes.
Let's handle that.
It'll be real quick, unless you have questions. The 3 documents on your iPads, which hopefully you had a chance to glance at over the weekend. Let's see. They are number 22, 20, 21, 22, and 23. And this is for the rule that you voted on last month to eliminate the meeting requirement for licensure reinstate a license. They're the same documents that you had for the other rulemaking thing we did recently with the online submissions. They're pretty straightforward. It's just a fairly simple change. So unless you have any questions, I would just ask that you all would approve those documents.
Move to approve.
Second.
Okay, we're approving 3 documents. Is that right, Mallory?
That's correct.
3
The one that's numbered 21 has several different components to it. So yeah, it's in one document here, but it's technically like 3 combined there. So
Well, 22, we're approving 22, the governor's questions as well.
the governor's questions, and 23, the regulatory flexibility analysis
All
memo.
right, so your motion, Ms. Franks, is to incorporate all of those into one motion, correct?
Yes, it is.
Okay, thank you. And your second was Mr. Chara. All right, the motion is in front of commission. Is there discussion? This is fairly perfunctory. I'm not sure what that means, but it appears to be appropriate. Any discussion? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Thank you, Ms. Kirby. Mr. Young,
Yes, sir.
Executive Director report.
Okay, mine's gonna be real quick because I
Perfect.
know you're ready to speed up here. I have filed the director's report with you, and hopefully you've had time to read it. Just real quickly, the TREC 1 form we have proposed to divide into 2 forms, one for the licensee and one for the firm, as far as changes. And this is uploading into Core, just making it easier for online transactions with the licensees. We've established under education the TREC outreaches to be in August, September, and October. All of those dates have been confirmed with Malcolm Young and Mallory Kirby instructing. Also, the TREC courses have been published to the developers, and I know that the developers are starting to work on the development of those courses. Under legislative update, Mallory in the May meeting talked a little bit about the temporary retirement, but one of the things I would also like to point out is there was another piece of legislation that passed, which is the Right to Earn a Living Act. And what this actually does is instead of raising the bar for entrance of licensing, it lowers the bar. But it is something that was approved by the legislature, not specific to real estate, but overall licensing, which I think that you needed to be aware of. Under the customer service area.
Wait just a second. So how much does it lower the bar?
And in what ways?
Well, if you will go to about the 3rd page, it basically says, yes, it's basically the entry regulations. For example, they would probably discourage this body from raising the hours from, 90 to 180. That would be something that would be frowned upon with this proposal. So that would be, it's basically having to do with entrance requirements of receiving a license.
Ms. Kirby.
That's not exactly it. The bill, so it applies to all regulatory bodies within our department. Basically what it says is that the Government Operations Committee of the Senate and the House, by December of this year, each regulatory authority, so this commission would be one of those, has to submit all of their rules and policies to that committee to be reviewed. And then after January of 2018, each regulatory body has to do the same for right before your sunset every year, or I can't remember how long the sunsets are, maybe 2 years, I can't remember. But before that sunset is up, each time you have to submit all of your rules and policies for review by that committee in the legislature. Now they will review it, and there are 5, I think in the statute there are 5 factors that they will look at, which I think the summary I wrote for Malcolm's report, I think, has them listed about what they're going to be reviewing the regulations for. So it could be any of the regulations, not necessarily what is required for license or anything like that. And this is for all the boards and commissions within our department have to do this. If that committee sees something that they want changed or amended, they will bring that back to the governing body, and they can either make those changes or not. If the changes aren't made, then there's a risk that they will ask the General Assembly to sunset the commission at that point. So that's kind of an overview of the statute, and like I said, it affects our whole department, so the department administration will be telling us later how we need to go about complying with that. So it's not really something we need to worry about right now. It's just something I wanted to make you aware of that will be happening.
Moving on, customer service. Our staff not only went through a phone secret shopper, they've now gone through a email test in which emails have been inspected of responses to licensees. Also, the new platform for our customer service that not only includes email, but also phone inquiries with tickets that our staff is responding to as well. It's been a new platform to improve customer service with the commission. So those are kind of the highlights, of course, at the back end of the report.
Malcolm, excuse me, I have a question. Under customer service, I'm wondering this. Now that we have our new system, there are certain things that you're still required to send things in that, for instance, if you move a firm address, you cannot just do that online. You have to send it in, and is that correct?
Actually, you will be able to, as far as an address change?
Not an address change, but a firm address change.
You will be able to do that online.
I guess that's my point. The more that we can get online, is there any way that errors and omissions insurance could be paid online? Or does that go strictly to the vendor?
Basically, my goal with the errors and omissions insurance is with the electronic feeds, instead of the licensees sending in the verification, we can actually be able to check it off the feeds.
I love that.
I mean, that's kind of the goal. I mean, the whole goal with all of this core stuff is to go paperless.
Right. Okay.
And if you've been on the 4th floor, there's a lot of paper. So anyway, that concludes my report.
Thank you, Mr. Young. Any further questions for Mr. Young? All right. Back to you, Ms. Kirby. Let's start these consent order possibilities.
Okay. Any consent order authorized by the Commission should be signed by respondent and returned within 30 days. If said consent order is not signed and returned within the allotted time, the matter may proceed to a formal hearing. Now, the first thing I have on the report is a little bit different than the rest of the report. Occasionally, we'll bring a case to you that has been referred to litigation, and for whatever reason, the litigator recommends to close and flag that complaint should the person reapply for a license. Usually it's if they have an expired license or something like that. This is one of those cases, and this person is now wanting to retest and reapply for a license, and so that is this first incident. So the respondent currently has an expired license. It's been expired since since 2007, and would now like to retest and reapply. Respondent's file was flagged for 2 prior complaints. States complaint number 2007059541, filed in 2007, alleges that respondent had a binding contract with complainant's client. Complainant states seller, who was represented by respondent, contacted complainant directly about lowering complainant's commission to make the deal work. Respondent then sold the home to complainant's client directly and failed to provide the complainant with his commission. Respondent states that complainant brought a buyer to purchase the home, but the offer expired. Respondent states respondent received a call from someone who is not complainant's client, and the person purchased the home. Respondent later discovered that the purchaser of the home was the son of the complainant's client, but the purchase contract was with the son of the complainant's client. It appears the complainant and respondent were trying to work this outside of court. No supporting documentation was provided. The commission voted to close and flag in January of 2008. This might be because respondent's license expired on December 31st, 2007. Respondent responded to the complaint after the 10 days allowed by statute. Complaint 2007-065591 was filed by TREC in 2007 and was based upon an audit inspection. And the violations found were firm changed addresses without filing the change with TREC. Firm does not have a sign on the front of the office. Firm does not advertise with a phone number. The firm failed to properly maintain an escrow account by commingling funds, and one file review did not contain the agency disclosure. The file states that respondent changed the address to the current address, and respondent has since put a sign on the front door advertising the firm. Respondent states that the proof was not provided for advertisement, so respondent was not aware the firm number was missing. Respondent states the earnest money was deducted from respondent's commission at closing, so respondent thought it was earned money. Respondent states a friend relocated, and respondent must have overlooked the agency disclosure. The commission voted to close and flag in January 2008, assumingly because respondent's license expired December 31st, 2007. Respondent responded to the complaint after 10 days allowed by statute. And the recommendation is to allow respondent to move forward with retesting without any further action regarding these complaints. Licensees are required to keep transaction documents for 3 years, so it is unlikely that documents needed for an assessment of the first complaint would be available. It is legal counsel's opinion that any civil penalty that could have been issued for the inspection violations should have been done so at that time, even if respondent's license was expired at the time it was brought to the commission. Thus, the complaint should not be reopened to assess civil penalties for these violations.
So, do you need a motion to allow him to go forward, or just to take the flags off the file, or what are we trying to do with this case?
That would be so. The pursuant to the commission's vote back in 2008, it was flagged. Should the person try to reapply for a license? So this is just me asking you all if you want to let this person go ahead and retest and reapply, or if we need to reopen these complaints.
Mr. Bloom.
Yes, what was the purpose of the flags?
Well, the complaints were closed without any action because the license was expired. I mean, I assume that was the reason why the complaint was closed without any action, was because the license, by the time it was brought to the commission, the person's license was expired. And I don't know, it wasn't, there were no details in the minutes. I looked back at the minutes. It didn't say, maybe this person had told the litigator that they weren't in the business anymore, that they weren't going to be in the business anymore. So that may have been a reason why the litigator requested that as well. It just wasn't clear from the minutes.
So is he going back to be an affiliate? Is that what he would be testing for?
Yeah, you'd have to start over, wouldn't you?
I am not for sure about that. I think they actually wanted a broker's license, but I don't know that for sure.
All right, you've heard the report of the law department.
Did they pay the $2,000?
So there was no action on it. It was just closed. Otherwise, it would have just been a disciplinary action on their file, and it wouldn't have been
So
flagged.
he got nothing because his license expired. And now he's back and it's flagged, so we got to decide, do we let him go forward?
Right.
So he's wanting to come back in as a principal broker or a broker?
I believe a principal broker. I think this person before had a one-person firm. I don't know that for sure, but I think, hang on, let me see.
What's he been doing since then, or she?
I have no idea. The staff said this person requested to retest and reapply, and the only thing I have is what's in the file, which is just the complaints from before.
So, just generally speaking, if a file is flagged, that means when they reapply, there's an alert.
Right.
Okay, when you open that file with that alert in it, there doesn't say anything in it that is punitive or necessary to be completed before he can reapply.
Correct.
Is that true of all our flag files, do you think, or is that just in this case?
I mean, since I wasn't here when they did this one, I'm
know.
not really for sure, but I know some of the ones that you've flagged since I've been here, you've said that it has to be, they have to pay the civil penalty if they do apply for a license. So I know that since I've been here, you've authorized some different terms, but I don't know about back in 2008.
Well, if a civil penalty was issued for $2,000, let's say, and because his license had expired, they just closed the file and flagged it, would it be appropriate to open that file back up to say we can do it once you pay that $2,000 penalty?
Well, we never got to that point where the commission authorized a civil penalty, I don't think, from what I can tell from the file.
They just let it expire.
So I'd like to get to that point today, and I'd like to make a motion that he's fined $2,000.
And remain a principal broker?
No, he's got to take the test.
I think he needs to start back over.
Okay, that's fine.
How can we fine him if
First
we
thing.
don't know when it's already been hurt?
Well, it had to be flagged for some reason. He violated
Well,
something.
because he violated, no sign, no phone number, escrow account, commingling funds. These are serious charges.
We weren't here then, but I'm
Yeah, but I mean,
thinking
that's all we have to go by.
We fine him and then let him take the exam after he pays the fine.
Can we do that, Mallory?
I think so. I mean, I think if you want to authorize civil penalties for those violations, you can. Personally, I don't think it's very fair. I mean, I think the commission back in 2008 should have had them pay the civil penalties at that time.
So how about if we just let him, we allow him to reapply for an affiliate license? He's not been doing it for how many years? 8 years. He can't just go back and be a principal broker.
I agree with that.
So we won't, if we don't fine him the $2,000, I mean, you think that's too harsh? 'Cause we're talking about it.
If he hasn't been an agent, he would have to come back as an affiliate to me.
Me too, Fontaine.
I mean, the statute doesn't really say that your previous years as an affiliate broker to qualify for the broker has to be, that there can't be a gap. I mean, the statute doesn't really specify that.
Is he asking or she asking to come back, or did they ask that it be reopened? What's the status?
This person, according to the staff, they just relayed the request to me. I haven't actually spoken to this person. Wants to take the broker exam and retest and reapply.
But we could downgrade the license. We could downgrade it to he can reapply to be an affiliate broker.
You can do that.
I think, has somebody got a motion on the table?
I think you just made one.
Yeah.
I'll second that.
Okay, motion by Ms. Frank, second by Ms. Taylor, that this license, a previous licensee be allowed to retest for an affiliate broker's license. That's the motion as I understand it on the floor.
Right.
Is there discussion on the motion? All right, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. The second one, the first official complaint we've already heard, correct?
Correct.
Okay. The next complaint, number two, well, number one we handled with Ms. Page when she was here.
Right.
Number two, is that one that requires or suggesting monitoring the court action first?
No, this one was already in monitoring,
Okay.
and now we have
Can't give me a screen.
some information from the court.
Okay, so I don't think there's any need to read that into the record.
Okay.
Just give us new information.
Okay. So the new information is that the General Sessions Court dismissed the...
You didn't read the number in, did you?
Oh, you're right, I didn't. Sorry.
Get it right.
2015-002511. And the new information is that the General Sessions Court dismissed the underlying complaint against the property owners on the merits. Complainant and respondent have reached a settlement, and complainant requested the complaint be withdrawn. Respondent admits that respondent heard from a neighbor in passing there may be a potential suit or lien on the property. There's no documentation to support that respondent had any further information. The recommendation is to dismiss.
Move to dismiss.
Second.
I have a motion by Ms. Frank, seconded by Ms. Hills. This complaint be dismissed per council's recommendation. Discussion. All in favor of the motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 3.
2016-00651. On October 25th, 2015, complainant viewed a property that respondent listed. Complainant alleges that respondent violated duties of honesty and good faith to all parties and loyalty to respondent's client.
Mr. Chairman,
Yes, sir.
move to issue a consent order for litigation monitoring.
Second.
Is that a recommendation of council?
Yes.
Perfect. So Mr. McMullen has made a motion to accept council's recommendation and let the courts play this out before we handle it. I've got one
Who's working?
occasionally.
Okay.
it's more the operator than the
Mine's the
iPad.
one. Okay. Mine's the one that's
And
not
it was
right.
properly seconded by Mr. Wood. If the motion passes, we'll rehear this. We'll take it up once the court makes a decision. If you're in favor of the motion, please vote aye.
Aye.
If you're opposed, no. That motion passes unanimously. Number 4 and 5.
2016-00-1921 and 2016-00-1922. A complaint was filed by buyers who purchased a home listed by respondents on July 1st, 2015. Complainants state that several hours after closing, respondent's buyer's agent called to state that the property had a cracked foundation pier that caused the floor to bow. Respondents advised that the sellers had submitted a claim on their home warranty to repair the pier and that the coverage and claim would transfer to complainants. Complainants alleged respondents' failure to disclose the broken foundation pier prior to closing was unethical. Respondent 1 submitted a response by and through an attorney denying the allegations. In March 2015, sellers contacted Respondent 2 regarding the sale of the property and entered a listing agreement with Respondent's firm on May 20th, 2015, and executed a residential property disclosure which did not disclose any defects related to the foundation. Respondent 1 states respondents were not otherwise informed or aware of any such defects. Complainants submitted an offer on May 30th, and the agreement was bound by counteroffer on June 1st. Respondent 1 states that the seller emailed Respondent 1 on June 1st, informing Respondent that the seller noticed a cracked concrete block which was part of a pillar under the house, stating that the seller would like to fix the crack. Respondent 1 recommended the seller check the builder's warranty and recommended 2 structural engineers. Respondent 1 states that the concrete block in question appears to be easily viewable and was not concealed from view. On June 10th, Respondent 1 advised buyer's agent by email that Respondent 1 was going to be out of the office until June 22nd and informed buyer's agent to contact Respondent 2 regarding the transaction. Respondent 1 states that upon return on June 22nd, Respondent 1 discussed the status of the property with Respondent 2 and states that Respondent 2 had a conversation with the buyer's agent and let her know that the seller had begun working on getting the pillar inspected and resolved. Respondent 1 states that Respondent 2 relayed that the buyer's agent told Respondent 2 the complainants were okay with the issue as long as it was getting fixed. Respondent 1 sent an email on June 29th to seller requesting that seller leave copies of receipts for any repairs completed on the kitchen counter for complainants during the final walkthrough. Respondent states that the closing occurred July 1st, and Respondent 1 sent over the warranty information to buyer's agent as promised by Respondent 2. Respondent 1 states the brevity of the response email shows Respondent 1 believed Respondent 1 was forwarding paperwork to someone who was already aware of the matter. Respondent 1 states that the buyer's agent responded, stating they knew nothing about the structural issue. It is Respondent 1's opinion that the buyer's agent was alarmed by the terminology used by the warranty company referring to the crack as a structural issue. Respondents attempted to call buyer's agent within minutes of receiving the email to clarify that these documents were related to the concrete block. Respondent 1 states that buyer's agent did not deny that Respondent 2 discussed the concrete block, only that the buyer's agent was not informed of the structural claim. Respondent 1 recalls Respondent 2's frustration, stating, "I was sitting right here when I told her what was going on." Respondent 1 received a confirmation on July 28th that the warranty company covered the pillar repairs. Respondent 1 states that through conversations with Respondent 2 and buyer's agent, the concrete block was disclosed. Respondent 1 denies willfully doing anything unethical and states Respondent 1 acted in good faith, assisting seller with proactively resolving the issue. Respondent 2 submitted a response by and through an attorney stating that complainants had a home inspection prior to closing and states that the inspection was cleared and removed all inspection contingencies. Respondent 2 states that after the inspection and before the closing, the seller went under the home to install a vapor barrier as requested by the repair-replace agreement. While under the home, the seller noticed for the first time a small crack on one of the pillars. Respondent 2 states that the complainant's home inspector did not see the crack and did not include it in the report. Respondent 2 states the seller notified both agents, and Respondent 2 informed buyer's agent by phone, stating that the seller filed a warranty claim and paid the $250 deductible. Respondent 2 states that the repair was unable to be completed by the warranty company prior to closing, and Respondent 1 sent the warranty paperwork at closing. Respondent 2 states that at closing, buyer's agent and complainant stated they had not been made aware of the crack and or repair but closed anyway. Respondent 2 states that seller paid a $1,000 check to be held by complainant's title company until the warranty work was completed. Respondent 2 states that the repairs were completed and complainants released the $1,000 back to the sellers the first week of August. Respondent 2 denies violation of the Broker Act, stating Respondent 2 acted professionally, fairly, and in good faith throughout all communications. Respondent 2 acted in the best interest of the seller in facilitating the sale of the property. Respondent 2 alleges that buyer's agent failed to inform complainants about the crack prior to closing. Office of Legal Counsel reviewed the transaction documents, including correspondence with the sellers and respondents. There's an email dated June 7th to Respondent 1 from seller stating, I was looking around the house trying to get stuff ready for the inspection and found this. Looks like the top block and top block only is cracked. This is definitely going to show up in the inspection. I want to get it fixed. It appears Respondent 1 worked with the seller to check the builder's warranty and home warranty and attended the inspection on June 9th. An email from Respondent 1 to seller further states it could be the inspector misses it entirely, but if they do see it, we can make sure everybody knows we are aware and already have moved forward with addressing it. It appears on June 10th that buyer's agent sent the repair replace proposal to Respondent 2, which did not include the cracked foundation pier. Another email from seller to respondents dated June 11th states, when I had my guy come over to look at the repair replace list presented by the buyers to see what he could fix, we discovered that one of the support pillars under the house was cracked when looking at the vapor barrier line item. There is a letter dated June 16th from seller's home insurance company and a June 15th letter from the home warranty company, both acknowledging receipt of the structural claim. Further, there's an email from Respondent 1 to buyer's agent dated July 1st at 9:31 p.m., which delivers the home warranty letter and states the documents refer to the concrete block matters buyer's agent worked through with Respondent 2 while Respondent 1 was on vacation. Buyer's agent response states the document was being forwarded to their office's general contractor and principal broker as I was never informed of a structural claim being filed on this matter. It appears a structural engineer inspected the property on July 11th and the warranty did cover the repairs. It seems the disconnect between the parties revolved around the cracked concrete pillar being considered a structural issue. Seller provided a draft email intended for buyer's agent stating that seller informed respondents of the problem with the pillar but failed to provide the actual paperwork regarding the claim until the night of the closing. Respondents told seller not to send the email because buyer's agent was involving the broker. It is legal counsel's opinion there's not enough evidence to support failure of duty on their part of the respondents and that the seller should have disclosed the paperwork sooner. Recommendation is dismissed as to both respondents.
Second.
We have a motion by Commissioner McMullen, seconded by Commissioner Franks, that this complaint, the complaint against both respondents be dismissed. Is there discussion? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. Motion carries unanimously. Numbers 6 and 7.
Move to dismiss. Oh, she needs to read it in. Sorry.
That's okay. 2016-001961 and 2016-001962.
Move to dismiss.
For the audience's edification, these are two complaints that were filed against the principal brokers of the two respondents in the previous complaint. Since we found those respondents not in violation of any code, rule, or regulation, we dismiss those complaints, so it makes sense that we would also dismiss against their principal brokers. That's the motion on the floor. Is there discussion on the motion? Let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. Motion passes unanimously. And for those of you who are keeping track, there are 27 complaints today. We just finished number 7, okay? You're welcome. Numbers 8 and 9.
2016-002781, 2016-002782. Complaint was filed by complainant buyer against Respondent 1 listing agent and Respondent 2 buyer's agent. Complainant alleges that neither respondent worked ethically in ensuring that the repair replace amendment was completed prior to closing. Complainant states that Respondent 2 advised complainant to stay home in another state and Respondent 2 would complete the walkthrough to ensure the repairs had been completed. Complainant states that the crow's nest roof repair was never completed and that flashing on the roof was never repaired, causing leaks throughout the house. Complainant further states that both agents placed a 5-year roof warranty on the property, but the company would not uphold the warranty. Complainant further states that there is ice damage to the bay window that occurred 3 days after move-in and during the repair. Complainant was notified of previous ceiling leaks. Complainant states that water damage was not disclosed and the disclosure form left the portion regarding water damage blank. Complainant further states that the cable antenna was placed loosely on the roof after the roof company made repairs. Complainant further states that a flooring company advised complainant that a dishwasher leaked when the previous owners had the property and the bathrooms had overflowed, but this damage was not reported to complainant. Complainant states that the hardwood was rippled and buckled. Complainant further states that the plumbing in the master bath shower needs repaired. There's a substance that looks like mold in one of the cabinets, and the chimney needs repair. The laundry doors were broken. The fireplace is inoperable. The screens were cut. Boards on the deck were loose, and there is a bug infestation. Complainant also states that the house was not clean per the agreement, and Respondent 2 promised to paint the great room and kitchen, but never did. Complainant states that repair replace amendment stated that the rear pedestrian door would be repaired, but it was not repaired, causing a bad leak and flooding all of complainant's belongings that were boxed in the garage. Complainant states that respondent 1 will not return complainant's calls, and respondent 2 has told complainant to move on. Respondent 1, listing agent, submitted a response stating the roofing company made their warrantable repairs on December 29, 2014, in which the roofer adhered the shingles, inspected the flashing, and determined that the roof was functioning properly. Respondent 1 states that the home inspector noted bird droppings present on the brick veneer but did not climb the roof to verify the presence of birds. Seller was not aware of bird activity and were unable to locate any nests or entry by birds in the attic. Respondent 1 further states that the home inspector did not find water leaks at the roof or flashing, and the roof was not leaking during the listing period and up to possession. Respondent 1 states that there was no roof warranty put on the house as part of the transaction, but there was a warranty in place that was transferred automatically to complainant by the roof company. Respondent 1 called the roof company on January 28, 2015 to ensure the seller's invoice was sufficient for the 5-year warranty, and the roof company confirmed, stating that they would email Respondent 1 the paperwork, but the roof company never did. Respondent 1 states that the first time Respondent 1 became aware of ice damage prior leaks was upon receiving this complaint. Respondent 1 states that per the disclosure, the roof was replaced in 2013 and had not leaked since the sellers purchased the house after the roof was installed. Respondent 1 states that complainant did call a few times after closing, and Respondent 1 returned the messages. Respondent 1 states that the last communication was January 20th with Respondent's principal broker present, in which complainant threatened a lawsuit against Respondent 1 and the firm. Respondent 1 states principal broker and legal counsel advised Respondent 1 to no longer communicate with complainant. With regard to the antenna, Respondent 1 had no knowledge of the antenna and states that there was a satellite dish on the property during the listing, but neither the repair-replace proposal nor the amendment addressed that complainant wanted this fixed. With regard to the hardwood floors, Respondent states that the sellers had the dishwasher leak repaired on or about September of 2014, and the floors were repaired and dishwasher replaced with no residual issues or defects, and the home inspector did not note any defects with the flooring. Respondent 1 states that the seller did not misrepresent the current condition of the property. Respondent 1 further states that sellers used the master bathroom until they had moved out of the property and were unaware of any issues with the plumbing. Respondent 1 further states that the house was professionally cleaned on January 10th. Respondent states sellers did not have mold growing in the cabinet where complainant notified Respondent 1 of possible mold. Respondent 1 followed up with the cleaning company and the mold company that complainant hired and confirmed that there was no mold. Regarding the chimney, Respondent 1 states it was not requested on the repair amendment. Regarding the laundry doors, Respondent 1 had not heard of this item prior to receipt of the complaint and states the home inspector noted that the doors were not closed due to the dryer obstructing it, but complainant made no mention of the doors in the repair-replace amendment. With regard to the fireplace, Respondent 1 states that the sellers advised the fireplace had not been used and the fireplace and chimney had never been inspected. Respondent 1 states that the sellers placed a set of gas logs in the fireplace for decoration only, and that the sellers checked on the disclosure that it came with gas logs, but they intended to leave the logs as a decorative set. Respondent 1 states that they did not check that there was a gas starter and there was no intent to be misleading. Respondent states that the home inspector is discouraged from lighting fireplaces and recommended that the chimney be inspected. Respondent 1 states that complainant did not have the gas company inspect the logs, nor did complainant hire a chimney sweep. Respondent 1 states that the home inspection noted the screens were torn and complainant did not request the screens to be fixed. Respondent 1 states the deck boards were not discussed during the repair negotiations. Respondent 1 further states that the sellers occupied the property until about January 8, 2015, Respondent 1 had spent time in the house and never noticed any bugs. Respondent 1 further states the repair amendment requested that the rear door be repaired and did not indicate that work to the frame was needed. Respondent 1 states that the sellers made repairs to the door and sent photographs to the complainant ahead of the walkthrough and closing. Respondent 1 states that the door repair was not requested in the inspection release, but was requested in an email done as a courtesy by the seller. Respondent 1 states that at a final walkthrough, Respondent 2 discussed that complainant would not be happy with the condition of the door jambs, and they discussed their separate interpretations of door versus the entire door system. To Respondent 1's knowledge, the door was and has not been leaking, even with damaged door jambs. Respondent 1 states Respondent 2 notified complainant of the door frame and complainant proceeded to closing. Respondent 2, complainant's agent, responded stating that complainant was out of state during the home inspection and made a list of requested repairs from the report. Respondent 2 further states that complainant was out of state closing on complainant's old home and requested that Respondent 2 perform the final walkthrough. Respondent 2 states that Respondent 1 assured the roof repairs were made by the roof company. Respondent 2 states complainant was very disrespectful to the roof company and they have chosen not to honor the warranty. Respondent 2 states that there were no signs of leakage on the roof indicated in the inspection report. Respondent 2 further states the complainant was irrational in certain phone calls with complainant. Respondent 2 states Respondent 2 had no knowledge of water leaks showing up on the hardwood floors and nothing mentioned in their inspection report. Respondent 2 states that the master bathroom shower head had some movement but nothing unusual, and states the hot water tank was repaired twice per the repair list. Respondent 2 has no knowledge of a growth or mold and received a call from mold specialist whom complainant hired, stating that complainant became irate when mold was not found, and complainant asked the specialist to leave the home. Respondent 2 states Respondent 2 never told complainant Respondent 2 would replace the screens. Respondent 2 states the home inspection did not mention wood rot on the deck. Respondent 2 states that the entry door to the garage was in need of repair and was negotiated with the sellers, and a check for the repairs was at the home of the complainant when complainant took possession. Office of Legal Counsel reviewed the transaction documents, repair, replace, addendum executed by both parties states repair rear pedestrian door, replace leaking pressure relief valve on water heater, repair left drain line under master bathroom sink, fill holes in brickwork at eave line preventing future burr entry, have roof company who installed the roof in 2013 and gave a 5-year workmanship warranty come the week of December 29, 2014 to make any warrantable repairs to the shingles in the flashing area as recommended, have upstairs attic HVAC unit serviced, licensed HVAC company to be used. The property disclosure states that sellers acquired the property in May of 2013. It states that the roof was replaced in January of 2013. Sellers marked that they are unaware of any flooding problems, past or present, interior water intrusions from the outside the home, standing water and foundation, or property or structural damage from the flood, winds, or storms. Recommendation is to dismiss as to both respondents.
So moved.
Second.
Motion by Commissioner McMullen, seconded by Ms. Franks, that these two complaints be dismissed per council's recommendation. Is there discussion? All right, let's vote. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Just for a minute, think you had to write what Ms. Kirby just read, and then just think you had to read what she just read. It's nothing I would want to do. Thank you very much. Numbers 10 and 11.
2016-002821, 2016-002822. TREC
Motion to
Second.
I've got a motion by Mr. McMullen, who barely beat out Ms. Hills, seconded by Mr. Wood, to dismiss this complaint per council's recommendation, again against the principal brokers of the previous two respondents. Is there discussion? All in favor of the motion vote aye. Aye. Those opposed, no. The motion passes unanimously.
2016-003201. Respondent represented complainant in the purchase of a home which was set to close in the beginning of October. Respondent's firm also represented the sellers. Complainant states everything was going well until a mortgage company informed complainant that complainant was required to pay a $500 HOA initiation fee at the closing, which neither complainant or respondent were aware of. Complainant states issues arose causing the deal not to survive, and complainant decided not to close on the property. Complainant states respondent attempted to bribe complainant to get back in the deal with $500 cash, which complainant did not accept. Complainant states this was a self-serving gesture by respondent, as respondent and respondent's firms to lose thousands of dollars in commission if the deal did not close. Respondent requests stern punishment. Respondent and respondent in complaint number 2016003221 below filed a joint response. Respondent states everything was going fine in the transaction until the very end of September, when complainant states complainant was first informed of the $500 initiation fee to the HOA. Respondent states email documentation shows complainant was provided a copy of the covenants and restrictions as well as a print copy of the association information, and there were no hidden items, costs, or fees. Respondent states complainant was a real estate licensee. Respondent states there were no issues causing the deal not to survive, and there was no legal reason provided for complainant not to consummate the transaction. Respondent states complainant stopped communicating with everyone involved in the transaction after October 1st. Respondent states the cash offer bribe was an offer for the firm to cut commissions on the HUD and have the seller pay the association fee initiation using the money sellers would have saved on commission, and was in no way a bribe. Respondent states respondent was trying to make the buyer happy and get complainant into the home complainant was trying to buy. Respondent states respondent was kind and honest, and complainant wasted everyone's time and cost the sellers money. An email from complainant to respondent on October 1st, 2015 states we have decided to not proceed to the closing of the address of the property. It is not the right house for us. Thank you for your efforts. On August 29, 2015, seller's agent sent respondent an email with a fully executed purchase and sale agreement, which was executed by the sellers that day, as well as the covenants and restriction document, which discloses a $500 HOA initiation fee. The purchase and sale agreement also states the buyer shall be responsible for all homeowner or condominium association transfer fees. The recommendation is to dismiss.
Move to dismiss.
Second.
Motion by Ms. Hills, seconded by Ms. Franks, that this complaint be dismissed per council's recommendation. Discussion. All in favor of the motion vote aye.
Aye.
Those opposed, no. Motion passes unanimously. Number 14. No, sorry.
2016-003221.
Motion to dismiss. Second.
It's getting close. A motion by Mr. Char, second by Ms. Taylor, that this complaint against the principal broker of the previous licensee be dismissed. Is there discussion? Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. 14, please.
2016-003451. Complainant hired respondent to list complainant's house for sale. Complainant states respondent advised complainant that complainant's spouse would not have to sign to sell complainant's house since it was only in complainant's name, which turned out not to be true under Tennessee law. Complainant states this was misinterpretation. Complainant states respondent knew misrepresentation, Complainant states respondent knew complainant's spouse resided in the house, and the other residence respondent refers to is a tool shed built by complainant's spouse, which the spouse does not reside in. Complainant states complainant signed the listing agreement on July 10th, but did not receive a copy of that agreement until August 10th, 2015. Complainant states complainant's spouse got very ill and was diagnosed with lung cancer before the scheduled closing. Complainant states complainant asked respondent to request an extension for the closing 2 weeks before the scheduled closing, which respondent relayed was refused by the buyers because they had already scheduled their movers. Complainant states that complainant and spouse showed up at the closing with a written explanation of why they could not sell the house at this time and were told verbally by the sellers that they were only made aware of their request for an extension 48 hours prior. Complainant states respondent did not communicate this request to the buyers. Complainant believes respondent's firm had no incentive to pass along the request and said it would get their commission regardless. Complainant states complainant was contacted by the firm's attorney who stated complainant would be responsible for paying the commission on the failed contract. Complainant also alleges age discrimination. Complainant submitted an addendum to the complaint stating respondent is a licensed real estate broker and appraiser and was working to sell complainant's house. Complainant states respondent provided confidential information about respondent's broker's request for an appraisal, which caused complainant to distrust respondent as complainant's real estate agent. Complainant states respondent told complainant that respondent's broker drove respondent by a small house in the area and told him he would be getting a request for an appraisal of the house soon. Complainant states respondent said respondent's broker told him to keep in mind that her daughter would be getting the house in a divorce settlement. Complainant believes there's a confidentiality issue. Complainant also believes there is a conflict of interest when a real estate appraiser working as an affiliate broker under the direction of a real estate broker who is requesting an appraisal is a conflict of interest. Complainant also filed a response to respondent's response stating complainant told respondent that the spouse lived in complainant's house since the spouse sold his house in October of 2014. Complainant states respondent saw some of the spouse's belongings in the home and knew the spouse was living there. Complainant states complainant signed the listing agreement and respondent needed to get it to the broker for approval, so respondent promised to email a copy later and never did. Complainant states complainant asked for a few weeks extension, not an indefinite extension. Complainant states complainant did not sell based upon the email received from the title agent on September 10th, which said the spouse's signature would be required in order to sell the property, and the spouse refused to sign. Respondent states it is respondent's understanding that complainant and spouse lived in separate homes, and complainant assured respondent that complainant was the only owner of the home, and the spouse did not live there or have any interest in the home or any homestead rights in the home. Respondent states the spouse resides in a residence built on land split off from the residence the spouse sold the previous year for which respondent was the appraiser. Respondent states the fact that the spouse's signature was not needed to sell the home was confirmed by the title agent. Respondent states complainant signed and checked the box stating complainant received a copy of the listing agreement at the execution and a duplicate copy was sent on August 10th. Respondent states complainant verbally asked for an indefinite extension to the contract, which is passed along to the buyers via telephone message the same day. Buyer's agent responded the buyers could not accommodate the extension. Respondent states complainant did not file any complaints until complainant found out respondent's firm planned to sue for the execution of the completed contract and collect commission due. Respondent states the spouse was not a party to the listing or sales contract but was aware of both. Respondent states that the complainant changed the complainant's mind about selling the house and was looking for a legal excuse not to fulfill complainant's obligation. Respondent states complainant misrepresented the fact that the spouse resided in the home and the seriousness of the spouse's medical condition to do so. Respondent states notification of the spouse's illness was given only to the buyers and at the direction of complainant. Respondent states complainant willfully breached the contract and is now being sued by respondent's broker. Regarding the appraisal issue, respondent states complainant asked respondent about respondent's broker's daughter, and it was mentioned that an appraisal had been done on her house. Respondent states that the divorce is public knowledge and the value of the house was not disclosed. Respondent states no confidential information was divulged. Respondent states complainants concerned about the fairness of a divorce settlement are totally unrelated to respondent's real estate representation. Respondent states there is nothing in the use PAP that prohibits an appraiser from performing an appraisal for an employer, and there was no predetermined value, bias, or self-interest. Respondent states that the appraisal was not part of the settlement. Respondent denies any age discrimination. Text messages show complainant owned the property at issue here and the spouse owned another property in a different city. Whether this other property was the spouse's residence or a tool shed, as complainant states, is unclear. Text messages show respondent told complainant the spouse would not have to sign, which turned out to be true only because the buyer's lender agreed to accept non-marketable title. Respondent should probably not have spoken for the title agency by telling complainant the spouse's signature would not be needed to sell. However, respondent also indicated to complainant in an email that respondent guessed this might be because the spouse had threatened to sue the title company if they allowed the house to be sold, and the title company wanted to protect themselves from any potential claims under Tennessee marital law. It is unclear if respondent did not use reasonable skill and care in telling complainant that spouse's signature would be required, or if the spouse's actions, the threats to the title company, led to that outcome. Respondent included the last page of the listing agreement, which states the parties below have signed and acknowledged receipt of a copy, which is signed by complainant on July 10th. There is an email from complainant to respondent on September 8th stating complainant will sign close even without spouse's approval if it was possible. Respondent provided a text message from complainant on September 9th or 10th stating that the title agent confirmed with complainant that the lender will not require the spouse's signature to sell the house. An email from respondent to complainant on September 8th states that respondent had just spoken to spouse who would not be willing to sign or close for 3 months minimum. This email also states that respondent has just spoken to the buyer's agent who stated they would be willing to extend to Monday. The closing was originally scheduled for Thursday. Another email dated to September 8th from respondent to complainant says respondent explained the situation to the buyer's agent that morning and buyers could not accommodate the extension. It does appear this was the first time the 2-week extension was mentioned to the other agent, even though a text message indicates respondent told complainant respondent would talk to the other agent about the extension on August 29th. However, respondent claims that complainant's initial request was for an indefinite extension, which was relayed by phone and turned down by the buyer. So there's nothing to prove that the September 10th conversation between respondent and buyer's agent was the first time any extension had been requested. Text messages also indicate the complainant was fine with sharing the medical reason for the extension requested. The complaint was also filed with the Appraisers Commission, which was dismissed. The complaint stating that respondent was providing services to the complainant as a real estate agent, and thus the complaint is outside the purview of that commission. And the recommendation is to dismiss.
Motion by Commissioner McMullen, seconded by Commissioner Wood, that this complaint be dismissed per council's recommendation. Discussion. Let's vote. Those in favor of that motion, vote aye. Those opposed, no. The motion passes unanimously. Number 15.
2016-003-511.
Motion by Commissioner McMullen, seconded by Commissioner Wood, that this complaint against the previous licensee's principal broker be dismissed. Is there discussion? All those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. We're about to take about a 7-minute break, but before we do, we've got to say farewell to and safe travels to Commissioners Frank and DeChara, who are heading to Oklahoma City to represent this commission at the Association of Real Estate License Law Officials. Assuming you can get to the airport by 7 o'clock from here. So ladies, best of luck and get us some good information. Thanks for representing us. Mr. McMullen, are you ready to go? Commissioner McMullen is also leaving us at this point. He's in his going to his last meeting as an elected official in the city or town of? It's a city, okay. Oak Hill, which is it controls Davidson County. Is that right?
It's the heart of Davidson County.
So he's retiring after a successful career as mayor and alderman. Are you alderman there or councilor? Commissioner in the city of Oak Hill. So thank you, Commissioner.
Oh, there's some down there.
All right, with that said, about 7 minutes. We got about 10 complaints to go. We'll be done. 7-minute break.
A whole lot of fun going on.
safe.
I'm not thinking.
We're rolling through that, and everything's dismissed.
We'll try. Although we
Rolling,
don't
rolling,
have
rolling. No.
was a lot more fun.
That's probably
I got sleepy driving here.
Yeah, it's very convenient. We like it.
I might have to. I got sleepy driving here yesterday.
It's convenient to everything, I think.
Oh, I know.
And the traffic isn't bad relative to some of the other places you could buy.
Well, you know, that's where I shop. I mean, I
got
go
something
to
close that could show
Trader
in the
Joe's
morning.
every
Yes,
Saturday.
and if I can't get there by there, but I've gotten
Get to
home.
Franklin Road or I-65 real fast.
That was Patty's favorite
Oh,
neighborhood when she
but
lived here.
Austin got
Oh, the
big-
Republican of the year.
Yes, I was just so proud of him.
Yeah, John didn't mention that.
Yeah.
Traffic is so bad.
Well, we want to do stuff in town. And we don't want to have to go home.
Yeah,
come
it's
back
only
in
4
town.
miles. I mean, from my office, which is Music Road, to home is 4 miles. And I can get
Austin getting
there just no
a
matter
man of the year.
you know.
That was surprised? No.
Anybody names our kid Reagan?
There you go. Oh, yes. I didn't even think about it.
Spray your throat.
What?
You need to spray.
No, I just ate chocolate, which is probably bad for
Look
my
at that little red nose.
Well, Austin, they just keep piling these awards on top of you.
Yes, Austin.
Thank you for your direction. I was thinking for legislative proposals, maybe that we get some sort of statute. Oh, I know that.
Well, I don't know. I mean,
I've more than once.
I would like that.
I'm an approved instructor.
Yeah, we need to stop that.
No, that's horrible.
Time you ran.
So anyway, we can't figure out.
Hey, Valerie.
I knew you hadn't seen it.
No, I hadn't. I'm gonna look it up when I get home.
Personal counsel.
I didn't know that.
I submitted.
Because you didn't go through Jerry's, did you? Matthews.
About 2 blocks that way.
Oh, great.
Yeah, I've gotten a couple. I had to laugh. Somebody from Houma, Louisiana.
This is not really close to anything. They're just
I shot it back and I said my fee is
something maybe at the beginning to just kind of give us a roadmap.
what you're looking for.
Yeah, like
travel expenses. By the way, I live in Nashville, Tennessee.
No.
I did not hear back from them.
Yeah, I sent out a couple of those too. But I'm telling you, there's a lot of work involved in that.
Yes, there is.
I-
Let me tell
I
you
mean,
what. I do
put all the facts in there that are relevant. You know, I mean, I'm not complaining about it. I'm just wondering.
No, I
How
can
could we-
certainly try to do that. I mean, I wish I could shorten.
One of them.
I say like, you know,
So that's
this,
why I'm doing stuff.
somehow at the beginning something like, you know, looks like a 312 B5 problem, which is, you know, got to do this. And I mean, I know some of it may kind of tip, you know, 3 or 4 different statutes, but
I see.
You have a young fellow. No, he's
Just
involved
say
in
this
this.
is a frivolous complaint. No merit at all.
or maybe more say like
Thank you. I'll make it say that.
does not appear to touch on any of our rules or statutes.
I think he just got that.
That's came about because I told Austin I
That's
thought
an interesting
legislative initiative on our part
the,
might give you the authority to just dismiss frivolous complaints.
Oh,
Austin
so
reminded
then
me
that
that
lets
you.
me decide what's frivolous or not.
Yeah. There's plenty out there.
Cut down on the legal report, right?
Well, but see, we've got a great attorney right now.
This
What if we get, you know,
I keep on the sidelines and it's
Ups
just
and downs.
keeps on being a. Donna Garcia
Do they
called.
have anybody down there?
Donna Garcia called me. She said,
times they'll just read like, I think what some of the other commissions do is they'll read.
Well, yeah, how did you know that? That's what they always do.
Donna helped us in Memphis.
Or if it's a particularly,
I remember that.
All together agreed on one person.
I don't know, like our commission's quite a bit different because our
I
complaints.
did everything we did. I said, don't ever ask me to do something again. And if you don't tell me to do something. It was okay. I mean, they got Melanie, but it was right there anyway. Wasn't
Yeah,
it?
but I was trying to help Melanie, and
and a lot of that, I think, goes back to some of the
Martin, we were scared that he was trying to call the shots, but Martin's gotten so involved with
They've done nothing wrong.
I think foundation we could do, and case number.
I had some figured out that I turned right on it.
Started with that, and then
MAAR.
we had 4 or 5 people in there that kind of turned it around, but he did start it. But I don't think he had any bias. I don't think he had any bias one way or the other with her. She just.
But he.
Oh yeah. And we thought she was a good candidate. She wasn't us, she's as strong as the 2 we recommended. But she's doing a great job, I'll say that. She is doing a great job. She's staying out of the way. Nobody's after her.
Thanks for what you do. But I would be,
Pardon me?
I've said before, I'd be in favor of just
matured a lot.
reading the number and the recommendation.
Yeah. Did she work with you? Or you just knew her?
I complained to Brian McCormack about it.
She was the EO there?
For 8 years.
Okay.
I need to move around the block or do something.
Are you staying or going?
I'm staying. After 5 o'clock.
I'll
call you next week.
Okay, sounds good. Sorry I gotta leave.
That's all right.
The next 2 you should quickly move to this place.
Same ones?
Yeah, it's like the spouse of one of the previous ones filed the same complaint.
Okay, were you saying that I would?
Whoever you or whoever Rachel, yeah, will send us the.
Should we go ahead and say?
We could
I
cut it off.
okay.
Yeah, I mean, we could cut it off and say, I mean, after she reads the number, you could cut it off and say, I move to dismiss. And if somebody then wants to have her read it or discuss it or whatever, they could. But I mean, you could try it and see. Okay. I mean, the big thing was, I mean, were you on here when Fontaine took his seat. But yeah, they went off at the same time. So Wendell was the one who was so big about.
Oh, if you can answer this or not.
He would like yell at the.
How do you file it?
I liked him, but he was a little out of control. You know, but he's not
file
here anymore.
claims?
So why are we still living
I'm in
under this?
trouble.
Why are we still living under this crazy rule of reading a 3-page single-spaced document to us?
Okay, I'll try.
Yeah, man. Good luck.
Okay.
You got my support.
Okay.
See y'all later.
All right.
Have a safe trip home.
I see violations once or twice a year.
Be good.
I had to make a few phone calls. Well, then I walked
They've
him
gotten
back
to
and
where
we had to stop.
they're trying to forget
Here, right with you as well as you need me.
holders can make it fade away or stand out. Okay, thank you.
If you submit something like that, make sure you like have a picture.
He said, well, I had asthma trouble.
Oh, yeah.
We'll need something.
I'll document all of it.
Okay.
Thank you.
But, wow.
That person negotiates it, and it's run. But contracts or transaction report, you never, ever
And you think all happens is just but yeah, I
No, I'm just asking Clarissa. I mean, for me to have gotten sleepy on the way down yesterday, no, it's
5 hours.
4.5.
5.
And then I lose.
Actually,
I tell you what, I do
Mallory
need
and I
to
are
get
both
up and
laughing.
move, so y'all hurry up.
We're dinged out over here on cold, both of them so cold, but it's just like, yeah, but it's walked in, so-
16. I think 16. That's right through my line.
Okay.
All day today.
That's good. I don't-
I think I'm right.
Cold too. Yeah. I said, well, good. I said, at least I can't infect you.
each other. Dropping like flies.
Heard that.
All right, we're on number 16. Let the minutes reflect that Commissioners DeCharo, Franks, and McMullen are absent for the balance of this discussion. Ms. Kirby.
2016003431.
I want to move to take council's recommendation to dismiss.
Second.
What is the topic? I can't get my...
It's basically led on to the last one. I think it's
From
a
the
spouse of
tied
the
to
last
the-
one.
The spouse of the complainant
Yeah.
filed a separate complaint,
Yeah.
basically the same allegations.
Just magical.
All right, the motion on the floor is to accept council's recommendation and to dismiss. It's properly made by Commissioner Wood and seconded by Ms. Hills. Discussion, all in favor of the motion vote aye.
Aye.
Those opposed no. The motion passes unanimously. Number 17.
2016003481.
Move to dismiss. This is about the broker.
We have a motion by Commissioner Wood, seconded by Ms. Franks. Commissioner Wood, seconded by Ms. Franks, that
Miss Frank's not here.
I meant Ms. Taylor. You look, my fault. I was still trying to get the S off of Bobby's name.
Yeah.
Okay. Motion by Wood, seconded by Taylor to dismiss per council's recommendation. Discussion. All in favor of the motion vote aye.
Aye.
Those opposed no. The motion passes unanimously. Number 18.
2016003571. Respondent was the property manager for the property rented by complainant from December 2013 until November 2015. Complainant states respondent took 3 to 4 months to get repairs done, and respondent lied when doing so. Could get respondent out of when doing so could get respondent out of doing the requested repairs or other responsibilities. Complainant states complainant provided respondent with an abundance of personal documents, including bank statements with account numbers, pay stubs, utility bills, social security card, driver's license, etc. Complainant states respondent set up an account with online property management solution, which contains all of complainant's personal documents. Complainant states complainant has received past due notifications from respondent's website, even though complainant pays the owner directly and has never been late, and complainant refuses to correct this. Complainant is concerned this will affect the complainant's rental history. Complainant states complainant has requested respondent destroy complainant's personal documents and return the keys and garage door opener to the new property managers. The owner switched management companies, but respondent will not do so. Respondent states respondent used property management software for secure credit checks and applications, and after 30 days, the system automatically deletes the information from the file. Respondent states respondent only saves copies of the leases and not credit reports. Respondent states the property was new construction and informed complainant that repairs would be made under the builder's warranty for the first year. Respondent states respondent sent a repairman over to repair things not covered by the warranty just to make complainant happy. Respondent states all maintenance issues were handled in a timely fashion and were fixed. Respondent states complainant was rude to the maintenance worker and they refused to go to complainant's property because of complainant's attitude and vulgar language. Respondent states all keys and remotes were returned to the new property management company. Respondent states complainant is now paying the new company and should have transaction receipts from the owner showing her on-time payments. The lease is between complainant, tenant, and respondent's firm via agent respondent landlord. The lease agreement indicates a complainant paid rent directly to the owner. However, the lease agreement seems to indicate that the landlord should be responsible for the repair of the smoke detector, among other things. A spreadsheet of text messages between complainant and respondent was provided. Complainant made many requests over the 2-year lease period, some of which are probably not landlord's responsibility and some of which may have been tenant-induced. However, text messages from January of 2014 indicate the smoke alarm was faulty and respondent agreed to have it replaced under the builder's warranty. A message from March 19th from respondent to complainant states it has been hardwired and the electrical company is behind. A message from complainant to respondent on September 10th, 2015 states complainant had to have the smoke alarm fixed because respondent did not get it fixed. There is no documentation to show respondent maintains complainant's personal information. Respondent submitted a letter from the new management company stating they have received the keys in the garage opener from respondent. The recommendation is $250 for violation of TCA section 6213-4031, reasonable skill and care.
Mallory,
Yes.
what specifically are we talking about reasonable skill and care?
So the only thing that I really saw in the documentation was that it seemed to take more than 2 months to get a smoke detector repaired.
I move to approve.
Second.
Motion by Commissioner Bloom, seconded by Ms. Hills, that the recommendation of legal counsel be adopted. Is there a discussion on the motion? All in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 19.
2016-003591. TREC opened a complaint against respondent principal broker for failure to supervise previous respondent in case number 2016-003571 above, hereinafter affiliate broker. Respondent states affiliate broker helped the out-of-state buyer investor find tenants for several new construction homes and that the lease agreements were between the client and the tenant. Respondent states affiliate broker never used the online portal to store personal information or documents, but only to qualify applicants and with their consent. Respondent states affiliate broker never collected rent, but that the complainant paid directly to the owner's bank account. Respondent states respondent's firm did not manage the property, but that affiliate broker handled maintenance requests outside of the firm. Respondent states respondent received an email from complainant on September 10th who spoke to affiliate broker, and affiliate broker got the maintenance request resolved the same day. Respondent states affiliate broker performed professionally and ethically and feels the complaint has no merit. Recommendation is $250 for TCA section 6213-312B15, failure to supervise.
Motion to accept council's recommendation.
Second.
Motion by Ms. Hill, seconded by Mr. Wood. The council's recommendation be adopted. And a consent agreement of $250 be offered. So, did the broker, the supervising broker, feel like he was in the property management business or not?
Strange thing is that the principal broker said that the firm was not managing the property, and that the affiliate broker was doing the repairs like outside of the firm, which you don't have to license to do repairs, but the lease agreement has the firm as the landlord. So I don't know why that principal broker would think that they're not managing the property. So.
It seems to me either he's got an affiliate that's doing property management on the side in some form or fashion, or he's got a property management company.
Right. Mm-hmm.
Sounds like he's got a problem, is what he's got.
And, to me, I'm not sure the $250 accurately reflects the fact that this guy might be either not supervising, significantly not supervising, or operating and not disclosing that he is as a property management company when you inquired.
What would be the proper course for this agent to take in property management? One in property management, is there a course in property management?
This is on the broker.
This is the principal broker.
I know.
Mm-hmm. There is property management.
Well, why don't we, since the principal broker doesn't seem to think he's in the property management business, why don't we let him know that he is? And let's let him take a course in property management and make the fine. The fine's all right with me if he takes the course. $250 for the fine and takes the course in property management within 180 days or whatever it is, okay?
Yes, sir.
Mm-hmm.
You're on the floor. You've got it. Oh, is that a friendly amendment?
Yeah.
So, without objection, I believe the motion on the floor has been amended to increase the civil penalty to include property management course of how many hours did you think?
Well, I don't know how many.
Maybe say at least 6 hours.
At least 6
I don't know,
hours.
they may be 8, but say at least 6.
All right, we'll do it that way.
Or would you give them the alternative action of coming to one of these meetings for a day or two?
You can do either or, right?
Okay.
Great.
Okay, 250, so what's going to happen is if this motion passes, the legal department's going to go to this licensee and say, if you'll agree to pay a $250 civil penalty and take a 6-hour property management course or attend one of the full meetings of the Tennessee Real Estate Commission within the next 180 days, we'll get this thing out of the way. That licensee has the absolute right to say, I'm not going to do it. I want to come before the board in a full formal hearing with the administrative law judge. But that's his or her option. But that's what's in front of us at this point. All right, you've heard the motion. Any other discussion? All in favor of the motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 20.
2016-003631. Complainant states complainant and complainant's agent viewed and placed an offer on a property which was accepted. Complainant states complainant was told multiple offers came in and seller was going with the last best offer. Complainant states complainant's offer was accepted via email. However, complainant's agent was told the refrigerator was not going to be part of the deal. Complainant states that the agent then sold the house to another. Complainant states respondent is of low moral fiber and the email should be legally binding. Respondent submitted a response through respondent's principal broker. Respondent states respondent told principal broker that respondent had called for highest and best from both buyer's agents on November 13th. Respondent told principal broker that the seller would not accept the offer from a complainant unless the refrigerator and some of the window treatments were excluded from the offer. Respondent states respondent emailed complainant's agent on November 13th to get clarification that respondent would accept the removal of those items from the offer. Respondent states respondent had not heard anything back from the buyer's agent on November 15th, and respondent had received another offer. Respondent states there was never a signed counteroffer from complainant's agent or an email notification of acceptance of the counteroffer from seller. Respondent states complainant's agent called respondent on November 18th very upset because respondent's agent thought they had a contract on the house. Respondent states there was never a binding agreement with the complainant, and complainant's agent is at fault for not responding to respondent's emails. Respondent states respondent had a responsibility to present all offers to the seller and follow the wishes of the seller. No documentation of the binding agreement was provided. I requested that that be sent to me from the complainant by Monday, and I didn't receive anything. So,
Motion to accept council's recommendation.
Second.
We have a motion by Commissioner Hill, seconded by Commissioner Wood, that council's recommendation be adopted and this complaint be dismissed. Is there discussion? All in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Before we go further, Reverend Horn, have you ever heard people described as low moral fiber? Just want to check. I thought if anybody would heard it, you might have. All right. It was just a term in that complaint that I thought was interesting.
You could add that to your repertoire.
You are a low moral fiber. Number 21, please.
2016-003651.
Motion to accept council's recommendation.
Second.
This is a complaint filed against the principal broker of the previous complaint, which was dismissed. Ms. Hills made a motion to dismiss. Mr. Wood made a second to that motion based on council's recommendation. Is there discussion? All in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. 22.
2016-003671. Complainant states complainant and spouse were relocated to Tennessee due to military assignment. Complainant scheduled an appointment with respondent for November 21st for respondent to help complainant find a rental house. Complainant states respondent asked complainant to confirm what they were looking for in a house and told complainant it would be easier to find what they wanted if they bought a house and that there was not much that would fit their needs in rentals. Complainant states respondent said that if complainant's spouse was a good spouse, the spouse would not feel comfortable having complainant live in the areas where renters were available. Complainant states that knowing they had a short period of time to move, respondent said they could leave with keys in hand if they purchased, but that if they rented, Tennessee law says they cannot occupy the home for 30 days. Respondent states respondent used the information provided for the rental background check to get complainant spouse pre-approved for a home loan. Respondent states complainant requested only homes built after 2000, but respondent only wanted to show them homes that were older and run down. Complainant states none of the The homes complainant had found on Zillow were included on the respondent's list of available rentals. Complainant states respondent told complainant Zillow was not accurate and pulled up the MLS on the computer to prove it. Complainant said that respondent searched the homes under pending status, which did not produce the homes being searched. Complainant states complainant requested respondent change the search to active, and one of the houses complainant was interested in came up.
Commissioner Grease, would it be wrong to assume that we've all read this and I want to go ahead and accept council's recommendation to dismiss?
Are you of low moral fiber?
A little earlier, I think they'd vote that I was not of low moral fiber. So
All right, so I understand that Mr. Wood has made a motion to accept council's recommendation and dismiss this, seconded by Commissioner Horn. And to Mr. Wood's point, we received these complaints previous to this meeting, and our charge is to review those and hopefully have some grasp of what the nature of the complaint is. So it's appropriate. Is there discussion on Mr. Wood's motion? Let's vote then. Those in favor of the motion vote aye. Aye. Those opposed, no. Motion passes unanimously. Number 23.
2016-003701.
Motion to accept council's recommendation.
Motion by Commissioner Hill, seconded by Commissioner Horn, that the complaint against the principal broker in the previous complaint be dismissed per council's recommendation. All those in favor of the motion vote aye. Aye. Those opposed, no. The motion passes unanimously. Number 24.
2016-003951. Complainant states complainant put their property for sale by owner and respondent lived on the street and wanted to buy the house. Complainant states respondent never told complainant respondent was a real estate agent. Respondent wrote up a contract and paid complainant $20,000. Complainant states they had to leave the loan and insurance in complainant's name from 2008 till 2012 when complainants filed for bankruptcy. Complainant states respondent then paid off the loan and put it in respondent's name. Complainant states complainant cannot buy a house now because of this. Respondent states that in 2007, respondent noticed the neighbor had a for sale by owner sign in the front yard of the property, which is a double-wide manufactured house. Respondent states respondent stopped and talked to the complainant about the property and gave them the respondent's card and told them respondent is a real estate agent and an investor and was interested in buying properties on this street. Respondent states respondent offered to pay the asking price of $105,000 if respondent could put $20,000 down and take over the existing mortgage. Respondent states all parties agreed, and the closing attorney went over all the risks associated with this kind of financing. Respondent states that there was no commission paid, and since it was a personal transaction, it was not handled through respondent's firm. Respondent states respondent planned on refinancing the property as soon as respondent could find a lender, which respondent was not obligated to do per the agreement. But the economy took a downturn, and it was impossible for respondent to find financing. Respondent states respondent honored the agreement and made payments on time. Respondent states complainants were agitated that respondent could not refinance the property and get the loan out of their names. Respondent states that the agreement was somewhat open-ended, but respondent assured them respondent would pay it off as soon as possible. Respondent states complainant accused respondent of cheating them, even though they were extremely happy they got their full asking price the first day on the market with no repairs or cleaning and $20,000 cash. Respondent states respondent offered to sell it back to complainant at no profit, but they declined. Complainant then filed bankruptcy, and respondent enlisted the help of family members to help pay off the original mortgage. Respondent is sorry the sellers felt like they had to file bankruptcy to get out of the deal, but respondent believes it is complainant's financial habits and the bankruptcy which are keeping complainants from getting a mortgage, not the length of time it took respondent to refinance the deal. A sales contract signed by the parties and the settlement statement shows that respondent bought the property subject to the existing mortgage. The recommendation is to dismiss.
Move to accept council's recommendation.
Second.
Motion by Commissioner Wood, seconded by Commissioner Taylor, that council's recommendation be adopted and this complaint be dismissed. Is there discussion? Hearing none, those in favor of the motion vote aye. Aye. Those opposed, no. The motion passes unanimously. Number 25.
2016-006641.
Motion to accept
Motion by
council's-
Commissioner Hill, seconded by Commissioner Horn, that this complaint be dismissed since it was a duplicate complaint. Discussion? All in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 27.
26.
Oh, sorry.
2016-003971.
Motion to accept council's recommendation.
Second.
Motion by Commissioner Hills, seconded by Commissioner Taylor. The council's recommendation be adopted and this complaint be dismissed against the principal broker of the previous licensee. Principal broker of the previous licensee. Discussion on the motion. All in favor of the motion, vote aye.
Aye.
Those opposed, no. Motion passes unanimously. And as I was saying, number 27.
2016-006661.
Motion to accept council's recommendation.
We have a motion offered by Commissioner Hill, seconded by Commissioner Taylor, that this complaint, which was filed in error, be dismissed. Is there discussion? All in favor of the motion, vote aye. Those opposed, no. That motion passes unanimously.
They all voted.
Let the record reflect the vote was unanimous. Thank you, Ms. Kirby. Anything else from a legal perspective you'd like to talk to us about today?
I do not have anything.
You did yeoman's work. Great job. Okay, don't start signing out just yet. We'll go around the horn here. Mr. Young, do you have any final remarks before we're finished?
I do not. I think y'all have been very productive today with
Mr. Wood.
I would like to thank Ellen Roberts for coming and being with us on her birthday today. I know 29 is a special birthday, so we appreciate you coming today. But that's it.
Mr. Horn.
No, I just thank everybody for coming. Thank all the commissioners for your hard work. And always remember that a wet bird never flies at night.
Wet bird. A wet bird.
Daytime either.
The wet bird.
Miss Taylor, I'm going to have to think about that one.
Well,
moral fiber.
no, it's always a pleasure to be in Nashville. It's been an interesting meeting as usual. We hope you learned some things, as we always do. Thank you.
Mr. Bloom.
I'm just reminded in looking at these cases how many of them are brought to us because people don't put things in writing. And if there's ever a lesson we can learn from all these cases, I would hope we take that home with us. Put it in writing.
Thank you, Gary. Ms. Hills from Kingsport, in case you were wondering.
Just if you're a managing broker, today is June 1st, and your privilege tax. Don't get caught by not paying your privilege tax if you're a managing broker.
All right, just one piece of information. So, Malcolm, I think you're putting together wonderful staff. I don't want to talk about you, though. I want to talk about Miss Brooke in the back, who was married last Saturday in Vermont and thought enough of this commission to drive for like 24 hours to get back here for this meeting. So I want to recognize her efforts and wish Brooke and her husband best luck. All right, guys, sign out and be careful going home. Thanks for coming.